Good afternoon, respected President of the program, esteemed guests of honor, distinguished keynote speakers, learned professors, scholars, delegates, and participants from across the globe. We now formally commence the second day of the 2 days international conference on the legal dimensions of refugee data protection in the age of technology, which is organized jointly by the United Nations High Commissioner for Refugees, New Delhi, Dharmashastra National Law University, Jabalpur, Kalu Institute, Spain, Department of Studies in Law, University of Mysore, Department of Studies in Law, Karnataka University, Dharwad. Today, we're building upon the normative, legal, and human rights deliberation of the first day, that is yesterday. And today's session focused on institutional practices, ethical challenges, technological tools, and data governance in Global South in the domain of refugee and data protections. Discussion over today's is debated and to deeper on engagement of the comparative legal practices, operational realities, and interdisciplinary insight between the technology, refugee laws, and humanitarian practices. This deliberation continues to engage widely on the key themes: international refugee laws in the digital era, data protection, privacy norms, biometric identification, human rights and humanitarian data ethics, and implication of it on the state surveillance for refugee and vulnerability. With this foundation, the session today aims to advance a scholarly dialogue, policy-oriented discussion that evolving around the challenges and responsibility associated with the refugee data governance in the age of technology. Without further ado, may I now respectfully invite Professor M.S. Benjamin, Dean Faculty of Law, Chairman, Department of Studies in Law, University of Mysore, to kindly deliver the welcome address of the second day. Sir, over to you.
Thank you, Dr. Kudratasmi. Good morning or good afternoon, respected dignitaries, distinguished speakers, Professor V. Vijay Kumar, Professor Anupam Jha, Professor TVG N.S. Sudhakar, Professor N.S. Srinivasulu, Mr. Rudy Martinez, Professor Banerjee Chaka, Professor Chetan Singhai, esteemed colleagues, advocates, international legal scholars, human rights activists, scholars, students, dear participants, and ladies and gentlemen. It's my pleasure to welcome you all to the second day International Conference Hall, Legal Dimensions of Refugee Data Protection in the Age of Technology, organized by the Department of Law, University of Mysore, the Mysore, Karnataka, the Department of Law, Karnataka University, Dharwad, Karnataka, Kalu Institute, Madrid, Spain, UNHCR, New Delhi, and Dharmashastra National University, Jabalpur, Madhya Pradesh, India. Yesterday, as you witnessed, we have had a galaxy of legal luminaries. Professor Manoj Kumar Sinha, the former director, Indian Law Institute, Delhi, and current Vice Chancellor of Dharmashastra National University, Jabalpur, Madhya Pradesh, Professor A.M. Khan, Honorable Vice Chancellor, Karnataka University, Dharwad, Karnataka, India, Professor Viswanath M., Dean, Faculty of Law, Chairman, Department of Law, Karnataka University, Dharwad, Karnataka, delegates from UNHCR, Dr. Ragini Jutsi, Associate Protection Officer, Mr. Alessandro Tello, Senior DIMA Coordinator, Bangkok, Thailand, and Mr. Alberto Martos, President, Kalu Institute, Madrid, Spain. They all had intensive deliberations about the problems and challenges faced by the refugees in various countries. International Convention on Refugees of 1951 and its protocol of 1967, and how India extended shelter to refugees from Sri Lanka, China, Myanmar, Bangladesh, despite not being signatory to the International Convention on Refugees. Now, how to safeguard refugees' data in the digital world and consequences if data is breached and so on. With this brief note on the first day deliberations, I would like to extend a warm welcome to the guest of honor, Professor V. Vijay Kumar, the former Vice Chancellor, National Law University, Bhopal, Madhya Pradesh, the President Professor of Eminence and Advisor, the School of Law, Ramaya University of Applied Science, Bangalore, India, to distinguished speakers, Professor Anupam Jha, University of Delhi, the New Delhi, Professor TVG NS Sudhakar, West Bengal, National University of Judicial Sciences, Kolkata, India, Mr. Rudy Martinez, Sustainable Development Consultant, Kalu Institute, Madrid, Spain, Professor Banerjee Chaka, Dean, VIT-AP School of Law, Andhra Pradesh, India, Professor Chetan Singhai, Dean, School of Law, Chanakya University, Bangalore. I also extend my heartfelt gratitude to all the members of the organizing committee, Ms. Norma Romero, General Director, Kalu Institute, Madrid, Spain, Dr. Syed Kudrat Hasmi, Coordinator of the program, and Ms. Sarah Magban. I once again welcome you all to this important international.
Welcome and for contextualizing the scholarly focus of the second day of this conference. Now, I may request our keynote speaker, Professor Anupam Jha, Professor in charge, Law Center 2, University of Delhi, to kindly give a keynote address. Before, sir, we proceed with you, we would like to brief about you to our audience. I would like to request my colleague, Ms. Sarah Benjamin, to introduce you. Sarah, over to you.
It is my privilege to introduce Professor Dr. Anupam Jha, Professor in charge, Law Center 2, University of Delhi, one of India's leading legal educators and academic administrators. Professor Jha has an illustrious academic career spanning decades, marked by excellence in teaching, research, and institutional leadership. At Law Center 2, University of Delhi, he has played a pivotal role in shaping legal education, mentoring generations of law students, and fostering a culture of rigorous scholarship and practical engagement with the law. His academic interests include constitutional law, human rights, administrative law, and legal education reform, areas in which he has both taught extensively and guided significant research. He is widely respected for his commitment to academic integrity, student mentorship, and holistic legal training. Under his leadership, Law Center 2 has consistently contributed to national academic discourse, moot court excellence, and research output of high quality. His work continues to influence both classroom learning and broader discussions on law and justice in India. We are honored to have with us a scholar and leader whose decades of experience in legal education have inspired countless students and colleagues. Please join me in extending a warm welcome to Professor Dr. Anupam Jha, Professor in charge, Law Center 2, University of Delhi. Thank you.
Thank you, Sarah, for nicely introducing me. And I congratulate University of Mysore and University of Karnataka Legal Studies. And I have heard that an institute from Spain is also collaborating in this program. So I congratulate the institute from Spain also in organizing a very relevant and contemporary topic related to the refugees. In the age of the technology, the science and technology, how the science and technology is also affecting the life of refugees, University of Mysore's this symposium conference on the refugee protection led by Professor Benjamin is a remarkable event. And I hope that the participants, whom I have heard that the participants are mostly the students of law, and some of them are refugees also. So this is a very contemporary and relevant topic that has been selected by the University of Mysore and the different collaborating institutions. Friends, today I'll be taking up the problem of and also the development of artificial intelligence, algorithmic decision making, and the refugee management, because the technology is touching this area also. Although we have the convention of the 1950s on the refugee protection, but at that moment of time there was no such thing which was called big data. But in the last 10-15 years, the big data has changed the lives of the people. Now we have the AI system in every person's hands. Every mobile, which is called so-called smart mobiles, they have the artificial intelligence. So artificial intelligence works on the concept of big data. And this data is very important. The data was important in the earlier times also, because every refugee must be able to give basic data to the identifying authorities. But in today's times, the thing is that data is digitized. There was a time when data was put on record on the papers, but in today's times, it has become already different kind of thing. There is very less use of paper and a lot of use by the digital things. So we have lost our pen and paper. Now the students also, they do not write on the paper unless they have the examination system which is based on pen and paper. But apart from the examinations, the students, they also look at the artificial intelligence. So artificial intelligence, which works on algorithm, different types of algorithm, which is it can be useful, because only then the intelligence can work. So in the refugee management, as we all know that the refugee problem in the 21st century, that is also very, very serious, because the conflicts are not abating. The wars, every day we come to hear about a different kind of conflict which might have arisen. So people flee away from their homes, and sometimes there is also the problem of persecution. And as we all know that the convention which was concluded in 1950s after the two world wars, because world wars at that moment of time made lot of refugees. So that refugee problem, which arose in the 1950s, led to the conclusion of the convention and the protocol. But at that moment of time, data was not defined. In the convention, we have no word which is called as data. But at the same time, there were many other conventions which were concluded, like the human rights, because Second World War, the First World War, ultimately resulted in the grave breaches of the human rights of the people. So in that instrument, one of the instruments that was concluded in 1948 was UDHR, And the Universal Declaration of Human Rights, which was concluded on 10th of December 1948, that had a provision about the right to privacy. So right to privacy has been an integral pillar of the rights, human rights, which were granted after the Second World War to all the human beings, whether it be refugees or whether it would be asylum seekers or whether any person, maybe internally displaced persons or persons of concern. So the decision which had to be taken at that moment of time was that there is no such data which is involved. So how can we do it? But times are changing. Now we have the artificial intelligence. Now we have the algorithmic decision making, which we call ADM, algorithmic decision making, or the artificial intelligence. We have the machine learning tools. We have the algorithm which is based on risk scoring, like risk scoring means that giving a numerical value to assess the severity of risk. And nowadays, risk scoring algorithms are being used to understand the financial strength of a person, the financial transactions which were taken up, the transaction history of a person. And therefore, risk scoring algorithms are used. Sometimes algorithms are used to predict the behavior of the refugee. So in this situation, the law has also to keep up with this kind of pace of the technology. Fully automated algorithmic decision making sometimes becomes useful, and sometimes it does not become useful. Sometimes it is a retrograde kind of step. And we all can you might have heard that biometric application of the many technologies, like your fingerprint will be taken, your retina scan, your iris scan, all these things are being taken. All this is the data. Now we have such kind of data which could not have been taken before. In 1950s, the data might have been just the age or nationality or the family people member, ethnicity, religion, etc. All these things might have been a data on pen and paper. But now, apart from all these things, the person's color, the person's voice, the speaking manner, all these things, ethnicity, color, everything, these are all being recorded by the identifying machinery in relation to the refugees. So when we have to determine the refugee status, you all might be now knowing, because this is the second day of this conference. And yesterday, I am sure that the speakers might have told about the refugee status determination. So the status determination is a great hurdle for the refugees. First they become refugees, and then again they face another hurdle, that their status will have to be freshly determined. Now it's like someone commits the crime, and then the victim has to again face the court. That victim has to prove that the crime had taken place. So this is like that double kind of double problem, or the same situation is faced again. Now person has become refugee, and then refugee has to go to another country, because there is no international organization which has taken up the responsibility to take the refugees. Refugees will have to go to the territory, and territories are all taken up by the nations. So the nations have to ultimately give any kind of services, whether it be rescue services or whether it be some kind of basic human rights services, or such. Even determining that a person has become a refugee is a tedious task. But still, to determine the refugee status, data has to be taken. And nowadays, the governments are extensively using the new data systems by which data can be collected. And on that basis, maybe that asylum can be also sought. So once a person goes to another country, maybe that person can seek asylum. So the basis to seek asylum will be again based upon the data. And the data may not be the private data between the person who gives the data and the person who takes the data. It becomes not only mutual, but sometimes it leaks to the other places, and the places are very, very different places. It's not the place where localized place. It becomes available to all, and what we call it, a leakage of data. So the leakage of data, if that happens, then the human rights of refugees, those are challenged. Recently, you might have heard that many Afghan refugees' data were leaked by not by very developing country, a small country, but developed country like UK. It is being claimed now that the Ministry of Defense somehow leaked the data of the Afghan refugees. And those Afghani people, they were working in the UK army, or sometimes they were giving help to the UK army in Afghanistan when they were fighting Taliban. And recently, just 2-3 months back, it has been heard that those data were leaked. And I was happy to know that one of the law firms in UK had decided to sue the Ministry of Defense in the UK courts, that how this data leakage could be possible, because this has ultimately affected the lives of many. So because the report is that many of those refugees were killed once the data was leaked. So it becomes technology is sometimes useful, sometimes it is also a bane. It's a boon or a bane. The old debate about science being the boon or the bane, that debate is still going on. And but still AI is being used, algorithmic determination, algorithmic decision making, those are all being used, because cases have to be prioritized. The backlog of the matters has to be managed, because sometimes machine can do faster, and therefore backlog case management is also important. Identity management, it becomes very difficult to see through the pile up of the files where a refugee's data was put earlier. Nowadays, because of the data processing things, we can immediately quickly take up the matter and find out that whose data is kept where. So identity management, registration of refugees, all these things are done now electronically. The allocation of refugees to a particular official or to a particular ministry, Afghan refugees might be dealt with by a particular cell of a ministry, or then the other refugees might be dealt with by other cell of the same ministry. So there may be, and all these things can be done on the basis of, electronic mechanisms. So the surveillance also, many people say that by using these technologies, the state is going to make surveillance. But surveillance is not the right or the very good argument that surveillance is being used by the state, because on refugees, surveillance is normally used in the initial phases. If we take up the example of the Tibetan refugees in our country, when they had come because of their faith, we had no problem, and we thought that no, they will not be a security threat to the country. So at that moment of time, although they were also registered, every person was given shelter on the basis of at least a bit of data. But then at that moment of time, surveillance was also there. But nowadays, because of everywhere camera is installed, and the electronic data collection system, all these things are being used. The concept that surveillance is being increased, that is also, although sometimes it can be used as surveillance also, but more important than that is the risk of data leak. Once you collect the data, then it has to be, the legal dimension of that is that the data fiduciary, means the data to whom and the data is given, that entity must be having an obligation not to breach the data or not to share the data without the authority of the data giver. So because this will be a privacy risk, data protection, and this will lead to the privacy risk unless there has to be a consent. Informed consent must be there. So as we all know that because there was a contract that okay, data is being given, although the refugee, you can't say that refugee stands at the same footing, but then at least if you take the data from the refugee, then it has to be kept properly. It has not to be shared to any other people without the consent of the data giver, and therefore the consent is very important. If there is a lack of informed consent, then this will be not legal as far as the legal dimension is concerned. And this will also lead to the question relating to fairness. Suppose if we use the algorithm to predict a decision or to even make a decision, in that case what may happen, that someone may ask you that what was the reason of this decision. Now algorithm will not give you one reason, maybe because it runs on many things. So the procedural fairness question or the due process question, sometimes this may also be a question or a challenge for the countries or for the UNHCR or for any NGOs who are working in the field. And also maybe that the risk of non-refoulement, because this is a very important principle which is enshrined in the convention which was concluded in the 50s. Principle of non-refoulement means that person should not be thrown away back to the same country from where the person fled due to the fear of persecution. But if you take the data and if it is leaked, and the leakage may lead the data to go in the hands of the authorities of that same state from where he or she fled. So in that case, what will happen, that this will be a violation of the principle of non-refoulement, because ultimately maybe that the person may be, because you might have heard about the news that even the UNHCR data on the Myanmar Rohingya refugees, those were leaked, and somehow it came into the hands of Myanmar authorities. And it became very difficult for the Rohingya refugees who were in Bangladesh to save their lives. So say they had to be relocated to some other place, because once it came to it came in the knowledge of the authorities that the data has been leaked, then they had to be relocated. Because the human life is important, refugees' life is important. We must protect the life of the refugees, and therefore the important global instruments which have to be taken into consideration must be the general policy on personal data and privacy. This GDPP, General Policy on Personal Data and Privacy, which has been agreed by the UNHCR in 2022, that is also an important document that has to be taken care of by the domestic authorities also. And in 2025, a framework convention on AI and human rights, democracy, and the rule of law that has been concluded by the Council of Europe. And it is taunted as the first legally binding instrument convention on AI in Europe. So now European countries are trying to protect the data, but in the age of AI, it becomes very, very difficult to protect the data. And unless very strong measures are not taken, perhaps the refugees' data is always vulnerable to be leaked. And in the age of AI, so it is very important that proper security measures have to be taken by the humanitarian agencies and the UNHCR and the domestic authorities in this respect. As far as India is concerned, India has passed its domestic law on data protection, and thankfully it has not discriminated between the citizens and the refugees. It says that anyone who is on the territory of our country, and then the data. But yes, exceptions are there. If you look at the law on data protection, there are exceptions in the name of security. So in the name of security, or in the name of prosecution, or in the name of investigation, the data can be shared to the security agencies, and from there, suppose if the data is leaked, then again it becomes a problem. So India has perhaps I think that potentially India will have a very good data protection system, because the Supreme Court had also ruled in Puttaswamy case that right to privacy is a fundamental right of every person of this country. So I hope that my time is up, and I was so happy to share and talk to you, interact with you on this very important question of AI and refugees, and the international law, and how the refugee problem is being dealt with by the people, international community. So thank you so much for giving me time in your conference, which is organized online. I could have come to Mysore if this would have been in the offline mode, but it is very convenient for me also that sitting in Delhi, I could participate today in your conference. Thank you so much.
Thank you, sir. Thank you so much for illuminating address on the AI and refugee, machine learning and refugee. Now, I respectfully invite Professor Srinivasulu Ines, Professor of Law, West Bengal National Law University, Juridical Science, Kolkata, to address the gathering. So before we proceed, we would like to introduce you to our audience, and we shall proceed further.
It is a matter of great honor and privilege to welcome a truly distinguished academician and legal scholar of today's session, Professor Dr. Srinivasulu Ns, currently serving as Professor of Law at the National University of Juridical Sciences, Kolkata. Professor Srinivasulu is a widely respected figure in both national and international academic circles. He is a distinguished member of the International Council of Jurists, London, and a scientific member of the Canadian Institute for International Law, Ontario, Canada. He is also affiliated with the World Commission for Human Rights, London, reflecting his global commitment to advancing the rule of law and human rights. Beyond academia, Professor Srinivasulu has played a pivotal role in shaping public policy. He has worked with various ministries under the Government of India, including the Ministry of Justice, Ministry of Commerce, Ministry of Human Resource Development, and Ministry of Transport, as well as with the University Grants Commission. He has also offered policy advice to several state governments, including Karnataka, West Bengal, Assam, and Goa, especially on matters of legal education and law reform. Professor Srinivasulu's blend of deep academic scholarship and practical policy engagement makes him a rare and valuable resource in the field of legal education. His insights are bound to enrich our understanding and inspire meaningful dialogue among us. Please join me in extending a very warm welcome to Professor Dr. Srinivasulu NS.
Okay, we shall proceed to the next speaker, to Mr. Rudy Martinez. Sir, are you there? Next one. Unmute us. Yes, C is there. Sir, are you able to join? Yes.
Good afternoon.
Good afternoon.
Yeah, since I was the third speaker, I was a little lazy that I will join at 3:40 or whatever scheduled time. Doubtless, I have to jump to the second spot now. Refugee and data protection, or refugee data protection, as it is happening in the contemporary times, given the fact that the delicate concerns that refugee information, refugee data will have. At the same time, the refugee concerns are throwing greater challenges to the administration and to the governance. In terms of international law, we talk about people who are not having their own state, people who cannot stay in their own state, people who are driven away from their own state or the state where they have born and brought up, people who are not residing in their own state. Like this, quite a few terms, quite a few concerns with respect to individuals that we contemplate under international law. It is very interesting to observe that the fundamental principle of international law is to deal with the relations between the nations, not exactly about the relations between the people or the people's status or personhood. Individuals, citizens, or people's status or their personhood is largely left to the respective nations. The national laws, domestic laws, those would determine the issues concerned with their own people. Those people may be residing in their own nations or the people who are not residing in their nation. That is because the basic fabric of international law is to deal with nations, not with individuals, deal with the states, not with the citizens. But the issue of refugee brings about a very interesting state of mind, state of concern rather, under the broader umbrella of international law, wherein going away from the basic canons of international law, some impetus is being given to refugees, whom we call as people who are not absolutely stateless person. They are not termed as stateless person, but they are the people who are driven away from their own state or from their own nation. They have their own state, unlike the people who are stateless, people whom we call as stateless persons under the basic premise of international law. Of course, being a person who has educated from Mysore, who has observed the administration in and around Mysore from past 25 years, where a permanent refugee village is being established within 50 kilometers range of Mysore. We call that village as Bailukuppe, very close to Mysore, where there is one permanent refugee village for those people who have been driven away by the state of Tibet. Tibet refugee village is there at Mysore. Bailukuppe, the village is called. There are thousands of refugees coming from the state of Tibet are being housed, lodged, or given shelter, and they are living there happily. And of course, within the national laws as well, refugee concerns are having international importance. Therefore, local state government or local body government would not have any influence or would not have any role to play over there. Though the refugee village, refugee people are provided shelter in any small village or a town, which is basically coming under local body governance or state governance. For example, state of Karnataka governance, which is there around Mysore. But still, state of Karnataka will not have any role to play in running the administration of that refugee village near Mysore, because that is being done by the national government. And again, it is an international concern. So why I brought this example is, it is an international issue administered by the national government, housed by the local government. Different layers of governance are responsible for maintaining, ensuring the safety, security, well-being of the people whom we call as refugee in any given state. And again, who gets the refugee status, which state or which nation is really willing to grant that refugee status. On that also, there are no universally accepted norms or canons. For instance, even today, the fact that at Mysore or around Mysore, Tibet refugees are given shelter, to which China is having a greatest objection. Similarly, in the northeastern states, including Assam, we have given shelter, accommodation to refugees coming from Myanmar, Rohingya refugees, whatever they are known as. And again, that Myanmar or Burma is having some issues with regard to why we have given that kind of shelter and protection to those people who have come over there. So likewise, it all depends upon that particular context or that particular circumstance where from certain people are driven away from their own nation. And when I say driven away, that has not been done by the respective state government. There may be umpty number of reasons why they are driven out of their own nation or their own place and sought shelter somewhere else. And this is happening in an official way. In unofficial way also, there are number of people from different states, they are getting driven away, but you don't call them as refugees. For example, from the nation of Bangladesh. From Bangladesh, we have at least 1.5 crore people residing in the state of West Bengal alone. Across the country, there are at least 4 crores of Bangladesh people who are finding shelter, occupation, job, whatever in India. But they are not refugees. They are not driven away by their own nation, their own country, right? And they're also not stateless persons. They have their own state. Even Rohingyas have their own state, Burma. Tibetans have their own state. I mean, our Bailukuppe village residents, whom we call as the Tibetan refugees, they too have their own state, which is Tibet. Of course, whatever China may say that Tibet is part of China, Tibet is a state within the jurisdiction of China, but it is not recognized by international law. Therefore, you can say that refugees, Tibetan refugees who are staying around Mysore, they too have their own state. So here we need to debate and come to a consensus with regard to whom you actually call as refugee, who is actually a stateless person, who have just come over, crossed the border for finding some job. And when we go for maintaining the data, gathering information with respect to refugees, and especially aftermath of we brought Digital Data Protection Act of India 2023. In the background of the Supreme Court judgment in Puttaswamy case, wherein information has become part of privacy, human right, our right to life, and as such. So what type of information, what type of data pertinent to which type of persons, enjoying which type of status, not only under the international law, but as well under the domestic laws, what kind of status you have given, and what type of concerns those people whom you call as refugee, whom you call as stateless person, are the people who have just crossed the border for the purpose of finding job, so on and so forth. Just in the last year, maybe in the month of December, near Bangalore, one incident happened. Near Bangalore Hyderabad highway, there is a place called Kogilu Cross, people call it as. There, number of non-Kannada people, number of non-South Indian people, number of Bangladeshi people were residing by using some shelters and all that. And through some governmental measure, those people were, those shelters were removed, saying that this is illegal occupancy, traffic, whatever, all those government or public interest issues. And there again, the question cropped up, especially when there were people who have more than 500 people who actually came from Bangladesh in search of some job or some occupation whatsoever. If they are from Tamil Nadu or from Andhra Pradesh or some North Indian state and all, this debate would not have started. But you have displaced people who are not from your country, who are from other country, who have come to your country for some occupation and job. At the time, you entertained them. After they made their shelter, house, whatever, then you overthrown them, right? So literally, you have removed them, or you have displaced them. In fact, under the international law, we also talk about displaced people. The people have been made to leave the place where actually they belong to, right? So now these people you call these people whom government of Karnataka removed from that nearby Bangalore Kogilu to be displaced people, displaced by the government, displaced by nature, displaced by internal rebellion, displaced because of international happenings. These kind of issues, concerns we talk under international law. So the issue of refugee is not just about those people who have been driven away from their own nation. They may be displaced, if not driven away. They might have come to a particular place in search of job, and at that point of time, that particular nation has entertained them. For example, after Donald Trump 2.0 took charge, he started tightening the visa rules and all, and most of the Indians who are there in USA, especially in the field of software or in the field of medicine, they're finding difficulty. That's the reason why from past 1 year, most of the NRIs, non-resident Indians who are there in USA, they have not returned to country because if they return, they may not get back again. That visa extension may not happen if a gap more than a month takes place where they are placed outside USA. They have gone there. They might be having the visa to work there temporarily, or they may be those people whom the American government might have issued even the green card as well. But the distinction they're making that right, residents not born and brought up here, residents who have come here for occupation and settled. So we contemplate another term here, settlers. People who have come out of their own local vicinities and started finding occupation elsewhere and settled over there. They do not belong to that place. They are not born and brought up in that place, but they have settled there. They would like to make that place as their permanent, and they would like to ensure that their next generation will have that place to be their place of birth. Right? So these many different terms, terminologies we contemplate when it comes to administration, when it comes to governance, not only under the international law, but as well under the national laws and as well local laws. And every governmental norm or every governmental measure perhaps would like to keep some information, some data with respect to people. Those people may be their own citizens. Those people may not be their citizens. Those people may be their non-residents. Those people may be refugees. Those people may be stateless persons. Those people may be displaced persons. So every type of person, if you have housed in your own boundaries, as a matter of governance, you would like to keep their information. You would like to maintain their data, right? And while doing so, would you like to follow same criteria when you go for collecting data, information from your own citizens? Would you follow the same protocol when you obtain data from your own citizens, but they're not residing in your country, whom you call as non-residents? Would you follow same kind of protocol when you collect information and data from stateless persons or displaced persons? Whether refugee's status is above stateless person, whether refugee status is slightly beyond displaced person, would you give refugee a status which is equivalent to the status that you give to your own citizens or your own non-resident countrymen? So what kind of status that you give, that becomes more important, according to which you go about collecting data, collecting information. And especially when it comes to local governance, it becomes even more important because these people may not be enjoying the voting power. They may not be participating in the democratic form of governance, but they may be eligible to get government disbursement, including government subsidies or government grants whatsoever on humanitarian grounds. That's the reason why we contemplate always issues concerning refugees under international humanitarian law, not human rights law. Right? Human rights are inalienable, guaranteed. Nobody need to give. Nobody can breach without due process. So there is no issue concerning human rights. But when it comes to humanitarian, it is not purely depend upon the human being. It depends upon the nations. It depends upon the international relations. It depends upon the diplomacy. All those issues, covered under your humanitarian law, because where you are trying to give some facility, some support, some status to those people or a particular chunk of people who are not born in your country, who are not the people brought up by your country, who may not reside in our country little later, but still you are trying to give them some respect on pure humanitarian grounds. And sometimes it could happen that when a particular country or a couple of countries in wartime, there may be war victims. And because of that war situation, people may migrate from that country to adjacent countries. What is the status of these people? If you would like to maintain how many people crossed the border because of the fact that my adjacent country, neighbor country is in the state of war, right? You need to keep the numbers of them. If at all you're giving them some free beans and all that, or free grains and all that, you would like to keep a record, right? It's secondary whether you give them certain identity in terms of your Aadhaar card or identity card and all that for the sake of ensuring their identification. But still, under the international law, you need to keep a track of, you need to keep the data information with regard to people who have crossed your border, who have entered your borders. As a refugee, as a stateless person, as a war victim, or as a person who is displaced. So your international law or your humanitarian law talks about the fact that you need to maintain the information because you need to submit that to the United Nations. So therefore, when the nations embark on, the governments embark on collecting data, collecting information with reference to the people whom you call as refugees in that particular state, in a given status where those people are being driven away from their own local nation, what type of procedure, what type of due process you follow, that becomes very, very important. And on that matter, there are no international consensus. Different nations are following different type of methods, adopting different type of mechanism when it comes to maintenance of data and information pertinent to refugees. When it comes to India, when it comes to state of Karnataka and near Mysore, as I mentioned, where Tibetan refugees are being housed, thousands of Tibetan refugees are housed there. They are given identity card. They have their own passport. They can fly wherever they would like to. Only fact is that they do not have voting rights because they are neither citizens of this country, India, or they are not non-resident people, right? But all other facilities they enjoy, right? That's the reason why Dalai Lama, Tibetan, religious or spiritual leader, often visits India because he has got a lot of love and affection towards India, because not only at Mysore I mentioned, and in different parts of the country, such type of refugee colonies or refugee villages are being maintained on humanitarian grounds by India. Similarly, different nations are having their own virtues profiled when it comes to extending that shelter, extending that humanitarian platform for those people who are driven away from their nations for whatever reason. If the national government itself is the reason for which those people have got driven away from their own nation, the picture will be very different, because that nation would not like any other nation to give refugee status to those people who have left the nation, left their country against the local government. But if it is because of the armed rebellion or internal disturbance, or as I mentioned, wartime situation, or unemployment, poverty, drought condition, or whatever, which are beyond the control of any individual, which are beyond the control of any local government, in such a scenario, it may be a viable neutral scenario for other nations to extend that refugee status and maintain whatever data information belonging to those people, right? So the nation which is giving refugee status to the people who are driven away from their own nation need to address these concerns, why they have come out of their nation, because they are against the government, or because of the deeds of the government, because of the policy of the government, which the local government considers to be a anti-governmental activity, or they have been driven away because of this measure, or because of no governmental reason, or reasons which are beyond anyone's control. As I mentioned, armed rebellion, war kind of situation, or act of nature. So, especially when it comes to maintenance of data, processing of data, with regard to refugee, it is not just for the sake of having head count and for maintaining data with respect to how many people who are driven away from their own status are living in a particular country, or what type of support the local government is extending to them. At the same time, the information will have to be submitted to the international agencies like United Nations. It may not be a greater or universally accepted standard, but it's again on humanitarian grounds that you share this information with that country from where these refugees have been driven away. You need to share that information to the United Nations, because if people agree or not agree, United Nations is the international government, and it tries to ensure in a very, very, very mild way international governance. So therefore, it is not that according to your own whims and franchise, according to your own concerns or interests, you have housed the people whom you call as refugee. You need to maintain that data and supply that data to that country also, where from they got driven away. So, and again, as I mentioned, while collecting information, while collecting data, you also need to keep in mind what kind of status we have given to them. And arriving at that status itself is very, very difficult. Sometimes it becomes very difficult to differentiate between displaced persons and refugee. It becomes very difficult to differentiate between stateless persons and refugee, right? Only if you go through the basic canons, basic principles of or basic tenets of international law, then only one will be in a position to understand and analyze the difference between a stateless person, refugee, displaced person, so on and so forth. Generally, we think, as per the popular understanding, that people coming from elsewhere, people who do not belong to this country, people whom we do not even call as non-residents, they could be called as refugee. It may be very, very general understanding, but technically it is not so. So data collection, data maintenance, or information gathering with respect to refugee will have to be done after arriving at a conclusion or consensus with regard to what type of individuals, what type of people they are actually. And how exactly you differentiate between those people whom you call as refugee and displaced people, stateless persons, and your own citizens, including non-resident citizens as well. And at the same point of time, you need to also figure out why they have been driven away by their own nation, by the governmental forces, or by the reasons which are beyond anybody's control. Otherwise, it would be an issue for international diplomacy, or it may create international tension between at least those two nations, like it is happening nowadays between America and Venezuela, America and Iran. Every party to that dispute are having their own genuine concerns, their own genuine reasons for what they are doing, whatever they have done, and which may or may not be finding mentioning a reason as per the understood or established international diplomacy, or sometimes it may be throwing a greater challenge to international relations as well. And most importantly, any international diplomacy or any international relations related dispute would often arise because of individuals. That's again a very, very interesting issue that we need to debate here, because international law always talks about the relations between the nations, the disputes between the nations, concerns, issues, and challenges between the nations. But often nations fight because of the individual's interest. And a nation's international diplomacy also depends upon the individual who becomes the president, who becomes the prime minister, like what is happening in USA now, in comparison to the earlier administration. So, as per the popular notion, it is a gamut of law which deals with only the nations, the states. But at the end of the day, often you are dealing with individual issue or individual interest. It could be an individual concern who has occupied. Yeah, sorry for that technical glitch. So often it is because of the individuals who have gone from one place to other, there and here, or it is because of the way in which you have treated one particular individual coming from one particular nation, or sometimes it is because of the vision or mission of an individual who has embarked on a powerful seat. So it depends upon the individual or individualistic approach, individual concerns, based upon which the modern tenets, principles, or canons of international law are being formulated. Unlike how we understand international laws, tenets, and formulatory foundations to be. And the issue of refugee is one such thing. On refugee, no nation can have any law because it's an international issue, right? So there ought to be international consensus between and among nations. There may be refugee conventions and all that as formulated by your United Nations. But how far they are universally accepted? If there is an internationally acclaimed or agreed treaty, agreement, or norm as such with reference to how you go about treating refugees, why is that everyday refugee issue is a penultimate novel concern, new issue? And why is that every nation is embarking on adopting their own way, their own process in dealing with refugees? Why is that every time when you talk about refugee, every year, every day, it is throwing open a new challenge? Why is that always you need to figure out who is refugee? Why refugee is not defined under your international law? If it is defined, why? Even today, we have got no clarity, and especially when it comes to maintaining the data with respect to refugees. Why is that? We need to look at different concerns. And in the Indian context, especially aftermath of the Digital Data Protection Act of 2023, whose width, ambit, scope is very, very wide to include any data which is maintained in the digital platform. And given the fact that nowadays no data is maintained in the physical format, every data is maintained in the digital format only. Therefore, the data that you obtain from refugees, the data that you maintain regarding the refugee people would be very well covered under the parameters or scope of your Digital Data Protection Act of 2023, which became operational in the last year, especially in September when digital data protection rules got formulated or are promulgated by the Government of India. So what type of concerns or what type of status that the respective legislation that I just mentioned will be giving to the data belonging to refugees, whether the data that you collect from your own citizens, in the similar way you collect and maintain the data of refugees. So all these concerns, we need to address before talking about or before deliberating or before maintaining the data that belongs to refugees. First and foremost issue will be what type of refugee they are. Second one, how they are different from other individuals as per international law, like stateless persons, displaced person, wartime victims and all that. Third one, how differently or how equally you would treat refugees comparison with that of your own citizens and non-resident Indians. Would the privacy norms of your own country, would the human rights norms of your own country apply in the case of refugee data as well? Or it is broadly based upon the international humanitarian law that you not only give status to a refugee, not only govern a refugee, and as well maintain the data pertinent to that refugee. So these 5 or 6 concerns you need to ensure, address before documenting, maintaining any particular data or information pertinent to refugees. I'm not very sure how exactly the United Nations or UCRC has gone about it, the apex body or the nodal agency which deals with these issues as a daily routine matter. But as a common man or as a person from general public, I have tried to look at this aspect, look at this topic, and I have tried to enlighten with respect to how a common man understands refugee to be, or how a common man have concerns with when it comes to the maintenance of refugee data, and how the common man has got different types of versions, different type of concerns to be clarified, doubts, ambiguities, confusions when it comes to different terminologies under international law. And when a common man compares refugee with that of other people who are also not people or citizens from our own country, right? So likewise, how a common man tries to understand, or in what way common man would like to look at this particular issue of refugee, that I try to present, having taken this wonderful opportunity given by my own alma mater, University of Mysore. I hope, as I mentioned towards the end of my talk, that I spoke as a common man and not as an expert on refugee issues, or not as an expert on international law. Thank you. Thank you very much.
Thank you, sir, for your scholarly exposition and valuable contribution to today's deliberation. Now, we proceed to a special and technical policy-oriented session. I respectfully invite Mr. Rudy Martinez, Sustainable Development Consultant and Tutor at Kalu Institute, Spain. Sir, before we proceed with you, we would like to introduce you to our audience, then you may proceed further. Now I call upon Ms. Sarah Benjamin to introduce you to the audience. Sarah, over to you.
It is my pleasure to introduce a seasoned professional and expert in sustainable development, international cooperation, and humanitarian practice, Mr. Rudy Martinez, a sustainable development consultant and tutor with the Kalu Institute, Madrid, Spain. Mr. Martinez is a civil and logistic engineer by training from Polytech Clermont-Ferrand and brings over 19 years of international experience working in development, humanitarian aid, and emergency settings across more than 50 countries in Europe, Latin America, Asia, and Africa. Throughout his distinguished career, Mr. Martinez has contributed to the design and evaluation of cooperation strategies and policies for international cooperation agencies, United Nations entities, numerous NGOs, and global engineering firms. As a tutor with the Kalu Institute, a globally recognized center for humanitarian education rooted in operational relevance, Mr. Martinez supports capacity building efforts that translate knowledge into practice in fragile and crisis affected environments. We are honored to have him share his insights on education, sustainability, and adaptation, and to explore how knowledge and skills can strengthen resilience in vulnerable contexts. Please join me in extending a warm welcome to Mr. Rudy Martinez, Sustainable Development Consultant and Tutor, Kalu Institute, Madrid, Spain.
Thank you very much. Just before starting, make sure that you can hear me properly and
Yes,
it's
you are
fine.
okay. Yes.
Wonderful.
Fine.
Thank you very much. Good morning, good afternoon, depending on where you are connecting. Thank you very much to all of you for getting me on board and to give me the opportunity to share a while with you, because it's really interesting for me to share my experiences, but also to give some overviews of issues that might be not the one that we are used to deal with when we are on a theoretical approach to these issues, working with humanitarian aid and refugees and displaced people and so on. For me, it's an honor. I had the chance to participate to another training that you held some months ago, and for me it was a really nice experience, and I'm really happy to have the opportunity to repeat that and to move on a different topic, which is quite important. I believe that obviously interesting in the way that people that are going to use this kind of tools on site need to know, but also because it's difficult to have information available on these topics and these issues. I'm going to share my presentation, so I will be talking with some slides on the screen. Give me one sec to make sure that it's working properly. Okay. Let's try to do it this way and see if it's working. Just can you confirm that you are seeing me and also
Yes.
the presentation?
Yes.
Wonderful. Thank you very much. Perfect. So let's start. I will try to talk something like around 40 minutes, more or less. I would be very happy to receive and to answer questions and doubts at the end of the presentation. I will try to answer to everything. If I don't have the information, I will make sure that I will forward any information extra afterwards, so you can get the responses. And the idea is today to introduce some challenges of using tools like Kobo Toolbox or Open Data Kit in displacement settings. And I called the presentation between utility and ethics. For me, it's an important issue to talk about. Before starting, just for you to understand who I am, I'm working on humanitarian aid and cooperation and development for now a little bit more than 21 years. I'm French and Spanish. I'm based in Madrid, but I've been working a long time outside, and I'm regularly right now going and back to different places, refugee camps, settlements, and so on. And I would say that I am using these tools on 95% of the cases. I mean, it's something that I'm using, I would say, daily. Experience is very important because you are facing a lot of issue, a lot of struggles, a lot of inconvenience on site, and it's important also to share this kind of experience because it helps a lot of people to understand what can be done, what could be done better, and how far we can go with this kind of tools, and also the responsibilities that these tools are supposing for all of us. I am saying all of us in the way that I'm talking also from the side of the user, but also the side from the beneficiaries that are giving some information, and we have to know what to do with this information, how to deal with that, and the way we should be responsible for the information that they are giving to us. I think that today we're going to explore a topic that lies at the intersection of operational urgency and ethical responsibilities, the use of digital data collection tools. I've based my presentation on two of them, Kobo Toolbox and Open Data Kit, even if Kobo Toolbox is in fact based also on Open Data Kit, but Open Data Kit gives you a little bit more options to personalize the tool itself. And we will talk about that in displacement and humanitarian crisis settings. These platforms are widely used because they enable rapid needs assessments and program monitoring, which is important because we are not only talking about the need assessment, gathering information, but also program monitoring in the way that we are gathering information not only to know what is the situation at a specific moment, but also how things are evolving during the implementation of an intervention, and to help us to monitor the progress of the project and the intervention. In fact, I would say that I'm using these tools on my side, I would say a little bit more than 60 to 70% for program monitoring, and the rest of the time for rapid need assessment or for gathering information in order to talk about baselines and things like that. But most of the time I'm using the tools is for program monitoring, which is also involving gathering sensitive information from beneficiaries and other institutions that is important to take into account. As many of you know from maybe direct experience, the features that make these tools effective are, for me, three of them: speed, mobility, and scalability. We can gather information very quickly, very fast. We can move wherever we want, and also in case of specific context where it's difficult to access, the scalability options are important because we can just move with our phone, with smartphone or tablets, whatever, and we can gather information all together at the same time. As an example, at some stage we had to gather information on very large scale, and I think we had at the same time something like 40 to 45 person at the same moment gathering information in 45 different places. and all of them going to the same server in order to aggregate the information. It's also important to introduce operational challenges, ethical challenges, and legal challenges. And this is why in this session we will examine key tensions that can arise when collecting and managing sensitive data from refugee and displaced persons. We will look also at how these tensions affect informed consent, data protection security, and also accountability, especially when we are operating under pressure, because obviously we are talking about situation that it's not only a question of gathering information, it's gathering information in such situations. We will also ground the discussion in a real field mission I've been involved. I will mention some of them. As I'm saying, I'm using that nearly in all my interventions. I have around 1 or 2 trips a month, meaning that I am working in at least, let's say, 15 different places during each year. And here I will talk only about specific cases. I've decided to talk about Syria, Mozambique, Mauritania, Haiti, Lebanon, and Niger. But at the end of the presentation, please feel free to ask any question, and I'm sure that I will also be in condition to illustrate or to respond to your questions through other intervention and places I am working with these tools. Finally, we will touch also on the legal frameworks, and especially we will talk about GDPR, General Data Protection Regulation compliance, and emergency exceptions, and reflect together on how we, as humanitarian professional or professional dedicated to this sector, how we can strike the right balance between utility and ethics in the field. And that's why I've called this presentation between utility and ethics through the challenges we are facing when we are using this kind of tools in displacement settings. So let's begin. I would like to first mention that which kind of digital tools we are talking about. Here I'm specifically talking about Kobo Toolbox and Open Data Kit, but there is a bunch of tools available. It depends a lot on what you are expecting from the tool, what kind of information you want to gather, and also, and maybe most importantly, what you want to do exactly with the information. On my side, I am specialized in gathering information through Kobo Toolbox and Open Data Kit, but also making some treatments through statistics softwares and SIG programs also, in order to create static and evolutive maps in order to show the information that we are gathering through these tools. I would say that these tools have become essential in humanitarian settings, especially when you are dealing with crises involving displacement and refugees. I've mentioned at the very beginning that they are widely used. I would say that they are widely used, but not massively used. And it's also still a bit of margin of progress that we still have on that, because people that are using it a lot, like me, but some of the people that could be using these kind of tools are not aware of their existence, or they think that's very complicated and so on. And that's why sometimes they are not including these tools in their daily work. I would say that we can define on 2 levels. We have the very basic user level, which can be solved through 2 or 3 hours training to understand what you have to do and how you can deal with the tool itself. And later on, you have an intermediate user level, which means that you are in condition to develop your formats, your files, to deploy the files, to organize the server, and so on and so on. I will not talk about more than 1 or 2 weeks of intensive training to be able to do that at a good level. Maybe on 2 or 3 days you can have a first approach, but by experience you will have a lot of problem and issues when you will be deploying the files on site, because there is so many issues that you have to take into account to make sure that everything is going to be under control when you will be working on site. That's why I believe that the training that I used to give on that try to be at least of 1 week, because I'm giving a lot of small tricks to make sure that people is aware of all the problems that they can face and how to deal with that. Over the last decade, these tools have transformed the way we collect data, we assess needs, and we plan responses. And in particular, I will say in fast evolving emergency, where reliable information is very hard to come by. The very plus of these tools that they are portable, adaptable, can be deployed very quickly, and that's this criteria makes them very ideal for the field mission in challenging environments like Syria, Mozambique, Niger, like I mentioned, or other places. It is also very used at development level, but let's try to focus specifically on humanitarian aid in this presentation. However, what is important also to mention is that the use of this tool is not without tension. The more we rely on this tool, the more we need to understand the ethical and legal implication of collecting sensitive data under pressure. And this includes ensuring informed consents, handling personally identifiable information responsibly, and maintaining compliance with international data protection laws like the GDPR. In today's session, we will explore the opportunities, the risks, and the tough choices practitioners must make when using digital tools in context of displacement. And this kind of tough choices that the practitioners has to make are the one that I was mentioning just a moment ago. Let's move on to the following slide. Utility, the value of digital tools in humanitarian operations. Let's begin by acknowledging that the immense value that digital tools like Kobo Toolbox or Open Data Kit bring to humanitarian questions and humanitarian operation. And I have like 4 big group of issues. First one will be speed and scales. These tools enable rapid data collection at scale, even in chaotic, fast-changing emergency contexts. What used to take weeks with paper forms can now be done in hours or days, dramatically improving responsiveness. Also, it is important here to mention that I've mentioned fast-changing emergency context. At some stage, it happened to me on site that you are going to the field, gathering information, and by the end of the day or by the end of the morning, some issues have been raising and so on, and you have to update the information, or it will be interesting to update the information to be more accurate. So as these tools are so fast to deploy, it's very easy to come back and to start again with the information you gather during the day to give it and to share it with your server and with your colleagues. Second point is standardization. They allow for consistency across different teams and location. Whether you're working in Lebanon or Mozambique, standard forms and data sets make comparison easier and improve coordination between partners. On my side, for example, I have different files that I am using, but one of them is aggregating all the information I have from all the places with specific questions that are common to everything. So meaning that I have the capacity to make a comparison between 10, 12, 20 or 30 countries where I have similar information that have been gathered at some stage. Offline functionality, and I think this is one of the strongest features that these tools are presenting. They have the ability to work without internet. Internet is key and is important in order to share the information, but it's not necessary to have it at all times in order to get the information, to gather the information, and when you get your internet connection, you will share it with your server. So meaning that in critical site where you have limited or absolutely no connectivity, it's enabling you to move forward very easily and smoothly with all the information you want to gather. That makes that the data collection is not disrupted and allow you to have a smoother operation. And finally, the fourth one, which is also for me very important, and depending on the kind of information you're gathering, it's maybe the most important one, is the real-time data access. While mobile supervisor and decision makers can monitor trends and needs as they emerge. I mean, you are gathering information and you have somebody that is checking this information and analyzing it. It's not necessary to be on site. You can be at the other office, at the headquarter office. You can be 10 kilometers away or 10,000 kilometers away. You're receiving the information. You can analyze it and you can send it back with decision making based on the information gathered nearly live, because you're receiving the information if you have the connectivity at this stage, and you can send it and receiving the feedback on real time. This real-time visibility enables faster and more informed decision making, which is obviously essential during crisis response. These are not just technical conveniences, they can directly impact in lives. I mean, faster needs assessment lead to quicker aid delivery and better decision making. With this power also comes the responsibility to address ethical and legal challenges, which we will explore in the next session. But obviously, I'm trying to give you all the added value and the very positive points that these kind of tools are bringing to us on our daily work when we are in this crisis situation. Okay, so coming back to ethical tensions in data collection. In this section, I would like to address the core ethical dilemmas that emerge when we collect data in displacement context. I've divided it in four different groups. There are more than that. Some of them are subgroups of this big one, depending on all the context we are facing. We have different context, different way to adapt our responses, and different way to propose and implement activity, meaning also that we have different kind of dilemma. But I've tried to make all together, based on also my experience, the most important one. The first one is linked to informed consent. The second one is linked to power dynamics. The third one is survey fatigue. And the fourth one is what we call secondary trauma. Linked to informed consent, it is not enough to display a consent form. In emergency settings, people may feel pressured to respond because they believe aid depends on what they are going to answer and what they are going to tell you. Literacy levels, trauma, and urgency all complicate the ability to truly give free and informed consent to the person that is interviewing you in such cases. So it's important just to take this into account and not assume that, as we've displayed a small consent form, that we've reached what was expected. Depending on the situation and the country's reason of displacement, the beneficiaries' situation, and so on, we have to decide which way is the best one. There is not a common solution. We can talk about a specific one later on, but I would say that most importantly, it's very important to remember that consent form is not sufficient when we display it. We have to go beyond that. Related to power dynamics, enumerators often hold perceived power, either as NGO representative or due to their affiliation with foreign actors. This may skew responses and create pressure to conform. We must reflect on how this dynamic affects the authenticity and ethics of the data. This is absolutely not trivial, and it's implying a lot of things when you are designing your files and your questionnaires, because depending on how you are going to ask something, obviously you will reach maybe a different answer depending on how open or how closed is the question and the way you are proposing the question to the beneficiary. So it's important to understand that you have to take this into account at the very beginning when you are developing before deploying the files. It's another issue that used to take 1 or 2 days to talk about. So many possible problems you can face related to that when we are working on trainings for this kind of tools. Linked to survey fatigue, in protracted crisis, people are often repeatedly surveyed without seeing tangible benefits, and you have to be aware of that. You might know that. You might take into account that maybe today you are making a survey, but yesterday they had another one, and maybe tomorrow they will have 2 others. So this is important to take into account because this leads to fatigue and distrust. And you must ask to yourself, are we collecting data to inform or just to report? And for me, this is a key issue when you are designing the questionnaires, because instead of sometimes asking for 30 questions, sometimes if you are selecting properly your question and you go to 5 or 6 of them, you might be reaching the same result at the end of the day. And finally, the secondary trauma. Asking respondents to relieve traumatic experience can deepen psychological wounds. So data collection must be sensitive, trauma-informed, and avoid unnecessary probing of painful events. Okay. Now we are going to talk about security and data protection concerns. In this section, I would like to talk about the growing risks surrounding data security and protection when you are using Kobo Toolbox and Open Data Kit in displacement context and humanitarian aid crisis. First, we must recognize that security threats in these things are not abstract. These are real issues, and you have to be clearly informed of that and to take it into account. Otherwise, you might generate a problem to yourself. They include real risk like hacking, data theft, and even targeted surveillance by state or non-state actors. Humanitarian data can be highly sensitive, especially if it contains identifying information about displaced persons or victims of violence. Second, the protection of sensitive data requires more than the password protection. Sorry, we need encrypted storage, restricted access protocols, and clear procedures for data backup, transfer, and deletion, particularly when field teams operate offline or with intermittent connectivity. Sorry.
Yes, sir.
Sorry. I had an issue because I was having a bug in my PC. Sorry for that. I'm going on. So yeah, you have to take this into account when we talk about the information that we are getting and how to make sure that these data are secured and under control. From a legal standpoint, GDPR compliance is mandatory for EU funded projects, but many organizations overlook the interplay with local data protection laws, which may have their own definition of consent, retention of, or reporting obligation. Finally, the risk of re-identification is often underestimated. Even anonymized data sets can sometimes be cross-referenced to uncover identity. So this has to be taken into account as it can endanger individuals, especially in context of political repression, for example, persecution or gender-based violence, for example. So as practitioner, our duty of care includes not just safeguarding lives, but also safeguarding data. Let's reflect on how our digital tools might expose people to risk they didn't consent to. So this is key when we are working on with this kind of data on site. Okay. Now, about data security and risk management. We shift a little bit our focus from legal framework to operational safeguards. I mean by that the actual measures that we must implement to keep sensitive data secure in the field. And to do that, I will talk about access control, data encryption, secure transfer and storage, and finally threat assessment. On the first one, access control, we must control who can access the data and how. I mean that it's not a question of just gathering information and put it into a server. Who can be allowed to have access to this server, who can treat the information, who can delete the information, who can copy it, who can access to 1, 2, or 3 bunch of interviews that we've received, and so on and so on. So that means that looking down devices used in the field, applying two-factor authentication, using password managers, and limiting administrative rights. A lost tablet in the field should not become a data break, but assign specific access levels depending on staff role. Not everyone needs access to everything. Sometimes when you're gathering information on the field, you can use your tab or your smartphone and you have it just with a specific right to gather information and set it to the server, but doesn't mean that you have access to the server to consult or to get or to retrieve information from it. Second one is data encryption. The encryption is non-negotiable. Both at rest and in transit, data should be encrypted using standard protocol. And if a device is stolen or intercepted, encryption ensures that the data cannot be read or misused. Field teams must understand that the importance of secure managing messaging apps and encrypted storage tools. I mean that you are using a specific tool to ensure the security of the data. you don't have to, and you mustn't share the part of the information through another system, another messaging app, or whatever, or another tool. And about the secure transfer and storage, which is a bit linked also with previous ones. It's important, especially when internet connectivity is weak or delayed, and how do we move the data securely from the field to the HQ, no? Avoid using USB or unsecure drive, use encrypted uploads, secure application programming interfaces, and also password protected file sharing systems. Even if it means delays, I mean that it may mean that it's going to take more time, but this extra time is to make sure that you are going to be secure and safely moving your information and your data. So cloud platforms can be useful, but must be vetted and compliant to make sure that you are securely transferring and storing the data that you are gathering. And threat assessment, it's important also because you have to make sure that you conduct a regular threat assessment, particularly in volatile regions. You have to ask yourself, who could be interested in this data? What will they do with this information? And based on that, you have to create mitigation strategies like deleting identifiers, delaying uploads, using remote web capability on lost devices, and so on. And finally, security and risk management are not only technical tasks, they are part of our humanitarian responsibility. So protecting data include and involve protecting people with who we are working with. Now I'm going to talk about balancing transparency and data protection. It's a common sense tension in humanitarian data collection. The need to be transparent with community and stakeholders, while at the same time we are protecting individual privacy and maintaining data security. We need obviously to find a balance between both of them. On one end, donors, authorities, and community demand visibility into how decisions are made, how needs are addressed, and how aid is distributed. On the other hand, we want a full transparency, especially with sensitive and individual level data, which can be very important to put people at risk. So this transparency is not always compatible with this part. Striking this balance requires clear internal protocols and context-specific judgments. I mean by that we need to know exactly what we are going to get as information, what we can share, what we cannot share, what has to be protected and under which procedures, and so on. About data anonymization and aggregation. Before sharing any data set, we must carefully remove identifiers and reduce precision that could enable re-identification. This means that we replace names with codes, generalizing location, aggregating data into safe clusters, instead of only talking about the GPS point that we took during the interview. We have to also aggregate the information through village level instead of household level, and so on. The goal of this is basically to preserve usefulness while ensuring safety. About clear communication with community, it's super important to explain in simple, accessible language how their data will be stored, will be protected, will be used, and when relevant, will be shared. This helps to build a trust with them and fosters also informed consent. It also empowers participants to ask questions or to decline, even in unequal power dynamics. I mean that sometimes it's better to inform a person and that person to be well informed that she is authorized or he is authorized not to answer, instead of provoking a response that is not desirable from one of the two parts. And finally, trust through predictability. A community become more cooperative when they understand the purpose of our intervention, and it's the same thing with data collection. They need to see what information is handled and if it is handled responsibly by you. Transparency about intentions, limits, and safeguard helps us to reduce suspicion, to gain confidence, and particularly in politically sensitive environment. About informed consent in digital collection, in digital data collection. The informed consent is not just a checkbox that we have to make sure that we did. It's a foundational principle of ethical data collection, and in particular when we are talking and we are working with vulnerable populations. So here we can talk about 4 different points: the benign consent methods, multimedia approaches, and tracking and documentation, and finally the right to withdraw. The consent must be freely given. I mean, specific, informed, and unambiguous consent has to be found, and this is a way you have to work with that. On the other hand, in displacement settings, this means that adapting procedure, you have to avoid coercive language, you have to explain clearly the consequence of participating to the interview, but also to explain the consequences of declining to participate to the process. You have to ensure people and participants don't feel obliged due to receiving aid, and you have to show that it's not a question of if you do not answer to that, you will not be included in the aid response. On multimedia approaches, I would say that traditional text-based consent forms often don't work in contexts where you have low literacy or language barriers. Sometimes using a video clip, a pictogram, or a small audio recording in local language can dramatically improve comprehension. So it's maybe trivial to say it this way, but I can assure you that it's not so common to see it on site, but it's working very well. Tools like Kobo Toolbox allow integration of such media directly into the form. So you go through your phone question by question, but you can show to somebody a small video or a small pictogram that can help them to understand what you are talking about. About tracking and documentation, it's crucial for me to log how and when consent was obtained. This includes digital signatures, a timestamp, or even an audio confirmation when culturally or legally acceptable. And these consent logs should be securely stored and accessible for audits or accountability checks to make sure that you have the authorization to treat or to use this information when it is sensitive. And also you have to include the possibility and the right to withdraw. The participants must be informed that they have a right to withdraw consent at any time without facing any negative consequences. This includes clear mechanism for doing so. For example, a contact person or feedback line, or even after the data has been collected, they know that this key person can be contacted in order to say, okay, look, I've been participating to that, but I would like to withdraw my information, and I will not be happy if my answer are used for the purpose of the interview. This topic is sometimes overlooked, but it is also important. I'm going to talk very very quickly about some real-world field experiences and the operation dilemmas, or some of the ethical and operational dilemmas that can arise. As I was mentioning, each context reveals very differently how digital data collection interacts with local dynamics, risks, and trust. So it's not a general approach. It's a very specific one, and can be not so easily used for other situation, but yes, to be adapted in question of responses. For example, in Syria, when dealing with earthquake victims or conflicts victims, in shelters, assessment post-displacement, we faced a dilemma. Being precise meant collecting granular household data, but this kind of collection was exposing vulnerable families to surveillance and retaliation. So in this case, we opted to make a safer option, to generalize a little bit the data, losing some targeting accuracy, but making sure that we get some data, but we are not generating any insecurity or unsafety for the families and the beneficiaries. In Mozambique, for example, in a cyclone emergency, it was a rapid post-cyclone response. Community members can express some skepticism about digital tools. Some can feel that the tablets or can be used for political profiling, for tax monitoring or whatever. So it's important to stop at this stage, to start re-engaging with the community, to show them the tools, to make them understand the purpose of the survey, and to understand that the kind of information we are gathering are not so sensitive and are not generating any problem for them in the future. But sometimes it's necessary to stop, to have a meeting with the people, a meeting with the community or community representatives, and share with them the whole information we want to gather, why we do it, how we are going to do it, which kind of questions they are going to answer, which kind of answer we are expecting, and so on and so on. For example, also in Mauritania, thinking about health services in remote areas, we are thinking about introducing biometric tools or equivalents in order to deploy them and to improve patient follow-up. But sometimes some of these biometric data are very sensitive, like fingerprinting, for example, or and so on, and it can raise some privacy concerns. So in this case, for example, technical failures also can lead to service delay or to erode trust. So it's important to give a step back sometimes and decide to move on with another option, even if technically or technologically it will be making a lot of sense, and it will make things happening faster. In question of, in this case, health services, sometimes you have to give a small step back and get a little bit more of perspective, and to reorientate not only the information that you're gathering through your tools, but also the way you're going to implement your activities. So sometimes these kind of issues or limitations also give you the opportunity to detect some specific problem that you have to take into account in your programmation and your activity implementation. Also, for example, in Niger on Haiti, when you are working with very insecure areas, maybe gun-controlled areas or urban areas like you can find in Haiti and so on. Sometimes the team reported that carrying tablets or visibly collecting data tools can make the staff target for robbery or suspicion. So in some area, the team had to switch to paper forms, conduct the interview discreetly, sacrificing a little bit the digital efficiency for safety. And later on, you can grab this information and include it in your digital tool. It's not the best way. It's sometimes necessary because you have to think about the safety of your beneficiaries, the communities you are working with, but also the safety of your own team. So it's a question of always looking for the balance between both things. So as a conclusion, in this case, tools must adapt to the context and not the other way around. And while you take this into account, your information, your data collection can be empowered. Also balancing accountability and operational realities. Here we can explore the structural tensions humanitarian teams face when they are trying to be both accountable and ethical while you are operating under pressure, because you have the delivery against the data protection. Field teams are under pressure to deliver results, but also they have to make sure that they ensure data protection is ensured, and this is taking a lot of time because you need to encrypt, you need to make sure that you have the consent, you have some time to to make anonymization of the information, and so on. So it's a constant trade-off between speed and ethics. On the other side, you have comprehensiveness against risk exposure. The more data you collect, the more insight you gain, but also the more risk you create. Because, for example, when you're collecting detailed GPS points or personal histories, you can help programming, but also you can expose these individuals to, in case the systems is compromised or there is a leak of data. Also, humanitarian principle against digital convenience. Digital tools often default to models that prioritize efficiency over neutrality, independence, or dignity. So you have to preset forms that may not align with community perception or evolving needs in order to make sure that you are under your humanitarian principles. Institutional responsibility versus partner capacity also. Large NGOs or donors may have strong protocols, but local partners often lack secure devices. So they need secure devices, they need training or legal awareness, and the burden shifts downstream, increasing risk of mishandling or unintentional harm. This section is here basically to challenge us to design workflow and tools that reflect both urgency and also ethic. And we have to clearly have the right balance between both of them. Here, very few recommendations and best practices, because we can talk about that hours and hours and days, because it's very, very complicated. And each time you have a specific issue that comes, you have so many problems and challenges that you can face on site. But basically, I would say that it's important to have contextualized informed consent protocols. It's important also to have measures of protection for the risk-based data. It's important to have ethical review boards for digital tools. Most organizations have ethical committees for medical or protection related research, but few review their own digital tools, and it has to be taken into account. We need to mainstream ethical scrutiny in the design and deployment of digital systems, especially those that collect personal data in displacement context. And finally, joint planning with community to build trust. We know that to build trust with community is key to make sure that the implementation of our activity in humanitarian aid is fundamental, but part of this work can lead us to gather information through these kind of tools, and it's important to include in this trust relation the explanation of how we are going to proceed, what we are going to do, which kind of tools, which kind of data they understand properly. They can or cannot participate. They just decide to do that. They can decide to do that at the beginning, but also they can withdraw themselves and so on. So it's very, very important to take this into account. And I would say that maybe as a general issue, it's maybe the first point to treat when you are working with a community and with your beneficiary, to make sure that you are building the sufficient trust to go ahead. Finally, some concluding reflection. As we reach the end of this session, just let me leave you with a few final points. Digital tools are not neutral. We've seen that every time we use Cobot Toolbox, Open Data Kit, or another one. We are not just collecting data. We are shaping relationship, but we are also shaping the profile of somebody. These tools influence on how we are perceived, who holds power in the data process, how decisions are made, and are we empowering communities, or are we extracting data for our own institutional needs? It's something very philosophical, but we need to take this into account when we design the data collection system. Ethics is not a checklist. It's not enough to tick boxes for consent, anonymization, or encryption. We have to make sure that ethical data practice are implemented, and we have to make sure that this ethical data practice require continuous questioning before doing the data collection, during the data collection, and after the data collection. The context can evolve, the risk can change, and our approaches must be flexible and thoughtful. We have to adapt continuously to the context itself. Humanitarian data practices must center dignity and rights. This includes that how we ask questions, how we store the information, and how we are going to share the information if we are going to do it. And also to make sure that affected people are not exposed to additional harm. Protecting dignity must come before ensuring efficiency. You have to make sure that you are protecting dignity of the people you are working with and gathering information before thinking about the efficiency of your intervention itself. And yeah, I would say maybe also as an open question to start maybe the debate and receiving some question from the audience. Who benefits most from the data we collect? Is it the community? Are there the donors? Is it the implementing agency, and so on? And often the answer is not clear, because it's not clear what we are collecting and which is the purpose of this data collection. So let's maybe talk about that. And yes, and that's it. I think this is most of the things I wanted to share with you. And as a very final slide before giving the microphone to the audience, I think that I will finish with a small different slide, and I want you to leave you with this simple image. It's not a question of superhero, it's a question of responsibility. With great power comes great responsibility. When you are getting all this information, you're gathering so many sensitive data and so on, you have to take into account that you are not only gathering information, but you are assuming a huge responsibility against this information you've been receiving. So we are interested in humanitarian work with people's stories, with traumas, with hopes, and we must treat this data not as number but as lives. And it's very important for me to finalize with that, because collecting data on vulnerable or not people gives us a power, but it also gives us the duty to protect, to respect, and to be accountable. Thank you.
Thank you, sir, for your engaging and practically grounded presentation, highlighting the critical and ethical consideration in humanitarian data collection. So let us see some questions, then we proceed with next speaker of the day. Is there any question? Yes, from audience, is there any question? So we see, okay, we see none. Now I have the privilege to invite Professor Dr. Banerjee Chakka, Professor and Dean, VIT AP School of Law, VIT AP University, to kindly share his thought on the refugee data protection. Sir, before we proceed with you, we would like to introduce you to our audience, then you may proceed further. Ms. Sarah, please proceed.
It is my privilege to introduce Professor Dr. Banerjee Chakka, Professor of Law and Dean of the VIT AP School of Law, VIT AP University, Andhra Pradesh. Professor Chakka is a distinguished legal scholar with strong international academic credentials. He holds a BA LLB honours from Andhra University, an LLM from School of Oriental and African Studies, University of London, and MPhil and PhD degrees in international law from Jawaharlal Nehru University, New Delhi. He was also a British Chevening Scholar, reflecting his academic excellence and global outlook. He has held senior academic and leadership positions at reputed institutions including Alliance School of Law, Symbiosis Law School, and NLU Assam, and has taught internationally at the National University of Ireland, Galway. Notably, he has also served as regional legal advisor to the International Committee of the Red Cross, contributing to humanitarian law practice in South Asia. We are honored to have with us a scholar whose academic leadership and global expertise enrich discussions on law, education, and social responsibility. Please join me in welcoming Professor Dr. Banerjee Chakka, Professor and Dean, VIT AP School of Law. Thank you.
Thank you very much, and good evening to all of you. It's a great privilege, and also it is an honor for me to be part of this prestigious conference, speaking on the very interesting topic of refugee law in times of critical situations. Like we have different perspectives of refugee protection today, and at the same time, the new and emerging technologies are making a different impact on the protection regime. So in this particular juncture, organizing a conference deliberating upon the digital technologies and its impact on the refugee protection is a very interesting workshop. And I thank and congratulate the University of Mysore and their partner organization, and having brought this particular topic for the debate and discussion. And I'm very thankful to the Dean and Head of the Law School at Mysore University, Professor Benjamin Sir, and also other organizers. And indeed, it's a great occasion for all of us too, because we are today observing 75 years of Statute of the Refugee Protection. And across the world, there are efforts of refugee protection, and we are trying to revisit where we are today with regard to the protection of the vulnerability of refugee population and migrants. When we look at all these aspects of international refugee law and protection, we all know that, and yesterday and today, most of you have been deliberating upon the framework conventions with regard to protection of the refugees and the International Covenant on Civil and Political Rights. All these mechanisms, which might have discussed. But today, I'm going to take you into a different premise, that is digital surveillances, national security, and vulnerability of the refugee population and their protections. Now, when we speak about this particular topic, and we have to look at it, three different approaches and three different aspects. Number one, who are the actors engaging in protection of the refugees traditionally and today? Second one, today when the state is evading the responsibility under the existing normative framework of human rights, constitutional obligation, and international legal instruments like refugee law, how are we going to attribute responsibilities in cases where they fail to provide certain protections which are attributed for the purpose of upholding the humanity of the refugee population when they're emerging from conflict areas or maybe mixed moments? And the third aspect which we will have to closely observe, the rising of non-state actors, those who are heavily involved in controlling the new and emerging technologies, which are heavily influencing even the state and its legislative machinery and its democratic processes. So in this particular three aspects, I am going to talk this particular presentation maybe for 25 to 30 minutes. After that, we can have some discussions. And if you look at that, primarily the topic which we are discussing and what I have selected, we have to look at it that, what is the political, the current nature of the non-state, the state system. If you look at that, today we have the growth of various migratory movements, both regular and irregular. And some of them have been fomented by the global network of communications and transportation, and that also led to the acceleration of economic disparity between North and South, which means a global North and global South. And at the same time, this particular problem is also accompanied by an increasing in forced mass exodus relating to various forms of political instabilities, massive violations of human rights, breakdown of the state, and ethnic, religious, cultural, intrastate conflicts. So if you look at that, ICRC persons, maybe yesterday they might have given some data to all of us. And when you look at that particular data today, millions of the refugees are still waiting for the protection from the state, for the basic protection of the rights of the individuals. In the midst of this, if you look at that, the states have been traditionally faced with a lot of potential threat to their internal order of mass influx of persons. But at the same time, such kind of influxes can threaten the delicate balance between the ethnic groups or pose major social, economic, and ecological problems with effect to the socio-economic stability of a receiving state. And from the perspective of the state, if you look at it, the refugees may engage in individual or group for internal acts of subversion, which can even threaten the political stability of a state or its societal values. This is what the perception which is coming up, growing perceptions across the world, that has been demonstrated by the framework legislations adopted by the some countries like Australia. And way back in 2013, the Australia has adopted certain legislations which are minimizing and restricting the protections of the people, those who are crossing from the borders. And the second thing, the United States of America, soon after, 25 years ago, after 9/11, and they have national security and patriotic acts, which have come up in the same lines, which are still continued to determine and restrict the movements and compromising on the refugee movements and the refugee protections. And also sometimes when we are looking at that grant of asylum, sometimes what the states are perceiving, that they can also soar the relationship between the sending state and the receiving states, like what we have our own backyard, like Rohingya problems. And if you look at that, the states are perceiving that refugees may engage in subversive activities against the country of origin, maybe sometimes, or maybe against the neighboring states, or may be involved in some kind of what you call it as acts of national security concern. So such traditional threats have today been supplemented by the potential engagement of individuals, those who are allowed entry into the state in an organized or large scale activities which are committed by the state against the protection of the refugees and the people, those who are seeking the permission to enter into the states in the borders. So this contemporary process of issues today are facing challenges from the national security, which is a new norm which is developed by the states. The second one, the digital surveillances, which are initiated by the states against the mass movement and exodus of the people, whether it is regular movements or irregular movements. If you look at that from the perspective of this kind of advances in communication and information technologies, trying to facilitate the cross-border movements and revolutionizing the finances and banking operations, and also coupled with evident reduction of the state authority, which resulted an increased and a novel threat to the state security. Like states perceive that these migrant population, whether it is regular or irregular, particularly the refugee population, people think that as an organized crime they may commit in the form of various things like national security perspective. They may say that it's a drug trade or the trafficking or smuggling of human persons, or maybe creating the global network which able to look into that what we call it as a loosely organized terminology of the terrorism. Okay, so this is the language which we are looking into that. But when this kind of background and the perception which is involved today in the context of the receiving or hosting of the refugee population by the countries where they are supposed to provide the asylum, which is now at heavily challenged. And the second important thing, the point which I would like to highlight in the context of this issue is that where today we are living in a complex area where the public and the private actors performing in a variety of functions safeguarding the national interest. And at the same time, if you look at that, this increased privatization, providing access to the algorithm governance, and what we call it as an algorithmization of the governance by the state for the purpose of the national security. The nation states are deploying the emerging technologies such as machine learning, artificial intelligence, and modern spyware system, and they are posing such an unprecedented risk to the fundamental rights of the people. And this kind of new norms of digitalization, digital surveillance, which have been deployed by the states, the nation state system, like we have come across, like in the cases of Cambridge Analytica or maybe Pegasus, which are considered as the most powerful hacking tool, or maybe spyware, developed to date, granting complete unrestricted access to the targeted mobile phones and all the information contained on those networking system. And the nation state and the governments are increasingly procuring this kind of powerful spyware and data mining and predictive tools by the private tech companies. Like we have another mechanism called Plantair. Plantair is considered to be involved in the serious human rights abuses worldwide. And if you look at that recent literature with regard to this use and abuse of the increasingly procuring powerful spyware using data mining, which are invented by the private companies, used in the democratic state and ruling, and the entire democratic process, the governance is completely made in algorithms. So that's why we call it as an algorithm governance, digitization of the governance. And this algorithmization poses one of the complete threat to the rights of the people. Like you don't have the privacy. And earlier speaker, we have seen that how this particular new and emerging technologies can be used for the purpose of providing better access to the humanitarian crisis. Today, most of the humanitarian organizations, they are heavily using technologies. Even if you look at that organization like ICRC, International Committee of the Red Cross, refugee agencies, or maybe other international organizations for migration, they're all using the new level of technologies in order to look at that influx of the people and provide necessary mechanisms wherewithal for the support of these migratory movements, being it economic migration or maybe emerging out of the conflicts which we have discussed. And they have been effectively using, and European countries are trying to comply with even the obligations of the GDPR. So to that extent, it is very positively we can see that one. But what happened in global south countries, particularly the developing countries like us, those who are regularly receiving thousands of refugees or migratory people, then the state is now looking at to use such kind of modern spyware and surveillance mechanism and tracking the people and restricting their movement. So in this context, what is the impact? The impact is on the very protection of the rights of the individuals, the very protection of the rights of the people, those who are otherwise given a normative framework under the existing rubrics of international law, that is a 1951 convention and followed by the protocol and we have the New York Declaration, and the 2016 and the 2018, we even adopted the Global Compact on Refugees and also the Global Compact on Orderly Migration. So when we have such kind of mechanisms, here you can see that the states are increasingly and involving, compromising on the mechanisms which earlier otherwise protected to the people, those who are seeking the asylum because of their well-founded fear of being persecuted. But today, the same individuals, like those who are having well-founded fear of being persecuted, when they are reaching to the borders and the borders are controlled by the mass surveillance system and digital technologies, and they are driven away by the states by saying that it is a national security threat. So this is the background which we are now talking today in the context of our legal system. So what is how we are going to look at it, this particular problem? And now the borders are heavily controlled by using the domestic legal systems. Let me make it myself very clear. When we are talking about that refugee protections, whether it is a refugee protection like the normative framework like Refugee Convention, Protocol, or maybe the what do you call it as the customary principles of international law, which provides the states an inherent obligation of providing the safety and security to the person, those who are seeking asylum at the borders. So that means the borders, so far, the borders have been regulated by the normative framework of international law. Like I could see that in a chat box, some people were asking earlier when our colleague, Dr. Professor Srinivas Lu, is speaking, that there was a question, and why there is a disparity of refugee protection system in India. Like if you look at that from the 1950s, the story of the refugees, if you look at that, India is hosting millions of the refugees, starting from the Tibetan refugees, Sri Lankan refugees, and followed by the refugees from Myanmar, refugees from the Bangladesh, or Iranians, Afghanistan, Sri Lankan. You look at that entire India's story of hosting the refugees and providing asylum. And it is all, even though India is not party to the 1951 Refugee Convention and Protocol, 1967 Protocol, by having a member of the EXCOM, that Executive Committee of the Refugee Commission, and one of the crucial member of the 2016 New York Declaration on the Refugee Protection, India has having a tremendous track record of providing refugee protection and giving the basic rights. To that extent, when we also look at that Supreme Court of India's judgment earlier, when we look at that, it is a clear testament of the commitment of the states where these refugee population and also the borders, international borders, have been regulated by invoking international normative framework. Now today, that particular regulation of international borders by international law is slowly diminishing, and now the international borders are regulated by the private domestic legal mechanisms of a particular country. I hope I'm making myself to all of you. So what does that mean? How international borders are regulated by the domestic law? Let's look at that, the current scenarios of various countries. And I take the classic example of Australia. Australia has got very heinous track record of not allowing people, those are, whether it is a traditional boat people or people are coming to reach the Australian borders. And since 2013, if you look at that, they have the legislations with regard to the domestic legislation with regard to the driving away the population, the refugee population in those who are reaching in Australia. And that particular things, if you look at that, it is very concern. Like why it is a concern? Because the Australian state, they're trying to expand its control of refugees in asylum seekers living in Australia by implementing the domestic legislation. So that means all this. Of course, if you talk about that, the national security, the state is a sovereign and they have to respect the sovereign borders. That is the fine. But when we talk about that refugees, those who are reaching to the borders with a well-founded fear of being persecuted, what happened in Article 1 of the United Nations Convention of the Refugee Protection. How do you apply your code of behaviors or maybe domestic legislations in order to control the borders? Like if I talk about that, there is a Australia, the Scott Morrison, 2013, I'm taking the example of that. In 2013, the Scott Morrison, the Australian then Minister of Immigration and Border Protection, announced that asylum seekers reaching to their countries are the communities, those who are living in that countries, they are subject to the new code of behavior that is called Morrison Code of Behavior, which raised that behavioral protocol exclusively applied for the asylum seekers, those who are reaching to their border. Is it not a classic example of international borders and refugee protection is now heavily regulated by the domestic law rather than international law? Now, what this particular Morrison Code of Behavior of 2013 says that there should be a behavior protocol that anyone released in the community has to adhere to this, and there should be a complaint mechanism for people who are concerned about the things that are able to report the activities of the people, those who are seeking asylum. And the code was introduced under the Migration Amendment Act and Regulation of 2013. This Department of Immigration and Border Protection 2013 rules were given and they are subject to the code, and asylum seekers who travel to Australia, particularly by boat or any one of them, they are variously characterized due to the political rhetorics and as a national security, they are queue jumpers, criminals, sexual deviants, and bored people. This kind of language they were using, and they were trying to compromise on the international protection, and that is where the vulnerability of the refugee protection is increasing. Even the successive governments have also implemented the same punitive policies. Purportedly, they deter the asylum seekers from reaching Australia via sea. And this particular code of behavior, my dear friends, look at that, compromises one of the many layers of the protections which are there under the international human rights law and also International Covenant on Civil and Political Rights and Refugee Protection. So, for example, we have the principles of non-refoulement. When we talk about that in the principles of non-refoulement, it is considered as a customary principles of international law, and it is also considered as peremptory norms of international law, such as jus cogens, and this jus cogens principles have been compromised and dampened by the border security regulations which they are. So that is a very, very ironical and paradoxical situation in the refugee protection today. That's how the digital surveillances or domestic legislations which are hampering and increasing the vulnerability of the people. And if you look at that of course, the national security remains the sole responsibility of each member state. The nation state have that every right to protect, but that cannot be compromised. The obligations given under the international legal mechanisms where you are supposed to align with your legal mechanisms. And what we say that, security, of course, is a legitimate interest of the states. The states has the right to protect itself and adopt the policies and measure to protect its population, including all residents under its jurisdiction, whether they are nationals or non-nationals. Please remember, whether they are national or non-national, they have to be protected. The states in good faith must also undertake international obligations of human rights, including international protection of the refugees, and to share the burden of the power countries where they are systematically denying the protections and of the refugee population and increasing the vulnerability. If you look at that, it is important to note that the legitimate interest of the security is must be always compatible within the international protection of the refugees. And it must be executed with respect for human rights. It's not that you can compromise. It's not that you have you are following that particular your domestic legislation and talking about that, compromising that mechanisms. It's not that. It is the obligation on the part of the state, and they must provide the security policies, the border regulations must be in compliance of your state obligations into the international human rights and international humanitarian protections. Like if you look at that and take, for example, that India's scenario, and we have the range of laws which are relevant to treat the refugees and border control. And that forms as the crux of the India's refugees regime. All foreign nationals, whether they are refugees, asylum seeker, or stateless peoples, must be governed under the Foreigners Act of 1946, and the Passport Entry into India Act of 1920, the Registration of the Foreigners Act of 1939, and the Citizenship Act of 1955. This is the legal regulation which we have for the purpose of controlling the borders, people, those who are entering into your country. But this mechanism cannot be compromised. But in addition to that, what we have to do, we have to pass certain legal orders under this act to deal with both legal and illegal foreigners. And what do you mean by that illegal foreigners? Or legal foreigners? The legal foreigners means those who are having the valid documentation and entering into your port. They may be regulated, but the people, those who are emerging out of human rights violations, or maybe racial and ethnic conflicts, xenophobia, or racist attacks, or maybe non-international armed conflicts. And when they are reaching, and it is the duty, it's a decision of the states to grant asylum or refugee status and allow them to stay in the country for the extended period, or maybe issue them long-term visas, and according to the passport control acts which we have in the India does it. Look at that. If you look at that, Section 5 of the Passport Act of India of 1920, the government has the authority. It authorizes the removal of any illegal foreigner by force. And the officials of the union and the states have conferred power to discharge their functions according to this particular rule. Here, a foreigner means a person who is not having the citizenship in India. It's very simple, as simple as that. But now, when it comes to that, the obligations under the Refugee Act, how are we going to address that particular problem? Like as I mentioned, India's refugee hospitality and their treatment is impressive. When you look at that historically, India has long been welcoming home to refugees from all over the world. Even before the advent of refugee law, if you look into that, India had given refugee to asylum to people those are escaping ethnic and religious persecution. And for example, Parsis, Jewish people, and Hindus and Sikhs in the wake of partition, refugees from the Tibet, as I mentioned, 1959, Bengali refugees in the post-1970 era, and genocide which happened, Tamil refugees, onset of the civil war in Sri Lanka, Afghan refugees and other refugee groups including Rohingyas, Chakmas, and even Somalis, Sudan, persons of Indian origins from Kenya and Uganda. The list goes endless. The country has provided that particular mechanisms. But today, since what I could say that because lack of maybe a political will or lack of adherence to the international legal principles, the countries like India may be compromising on the protections in what we have. The last 2 points which I would like to emphasize here is that number one, when we do not have the specific legal mechanisms like a Refugee Protection Act in our country, that maybe gives legitimacy of the state and its apparatus to compromise on the problems of international protection of the human rights regime. And no, whatever the reasons in India may be having with regard to the signing of and not having of domestic regulation, but that compromises the basic requirements of the protection of the principles of non-refoulement. And recent past we have seen the kind of statements given by the Honorable Supreme Court, and it's a clear evidence where the refugee population are at the vulnerability. And coming to that, the second important aspect is that digital surveillances. When we speak about the digital surveillances, using the various mechanisms of softwares like spywares, what I mentioned, it's like a Palantir and followed by the, sorry guys, I think there's a little disturbance from my side. A dog is barking. So please bear with me for that. So here, when we look at that, the use of state-of-the-art technologies which are penetrating into the privacy of the people, including the refugee population, that compromises and increases the vulnerability. Here, the one particular point which I would like to draw your attention is that if the state and the people in the high positions, when they make certain statement that gives that increases the vulnerability of the refugee population and their protection, like the statement given by some of the honorable judges with regard to the refugee organization and the people. Like they said that UNHCR opened a showroom and giving citizenship. This statement is what I consider as a student of human rights law and refugee law. It is a statement which compromises, which puts the refugee population into the more vulnerability. That is a primary problem. The secondary problem is that the state now imposing or maybe engaging the private entities, and the private entities are invoking the security measures for the purpose of controlling the border regulatory movement by using the spywares and malwares for the purpose of surveillance of these people that poses a threat to their right to life with dignity and their privacy. As we have seen that every human being, irrespective of your nationality or your citizenship, you must be governed by the basic principles of human rights law. And today, when we're talking about that Data Protection Act, under the Data Protection Act and the principles of privacy must comply with the obligations of international law, particularly humanitarian law and refugee law, so that the refugee population and the people, those who are emerging out of the conflict, can be protected their right. If you look at that, simple examples I can give you. When we talk about that 1951 Refugee Convention, and we have that, there are fundamental rights of the refugees and to the states. When we talk about that, Article 27, and even if you look at that, other regional conventions, the convention requires the state has the right and duty to ensure its own safety. And they also must exercise limits under the procedure which preserve both public safety and fundamental rights of the individual, those who are seeking the asylum. It's not my words. It's given by the regional mechanisms like Inter-American Convention of the Human Rights of 1986, Article 30, which speaks about that. And when we speak about that, the security implications, the international protection of the refugees, it is very clear that access to the national territory, the process of determining refugee status, the exercise of the rights and search for the durable solution, they are all integral part of Refugee Convention. If you look at that Article 31 of the Refugee Convention of 1951, it is the duty on the part of the state to provide protection to the people. And that is why it is troubling that when the interest of the national security comes and the exclusion clauses are actually being applied, even before determining whether the applicants meeting their definitional requirement, which is given under Article 1 of the Refugee Convention. So that is why I mentioned earlier that our conventions, like the border the controls today, is regulated by domestic law instead of international legal mechanisms. I think I will stop it here. Maybe if you have any pertinent questions, I'm happy to answer. Thank you so much for giving me this opportunity.
Thank you, sir, for such thoughtful and enriching address. So we are looking for some questions from audience. Is there any question?
Respected sir, myself Madhavendra Chakraborty from Assam University. My question is that to what extent can contemporary cross-border refugee migration be attributed to structural disequilibrium between the global north and the global south, and how do emerging technologies and data-driven governance frameworks reshape the legal protection, regulation, and vulnerability of refugees within this unequal global order? Thank you.
Okay, thank you very much. This is a very, very huge, the big question, and it requires at least some 15 minutes to 20 minutes a session for me. So let's look at that. I try to give that a very simple and very cogent answer. Let's look at that. Two important things. Now, the concerns of the global south and global north. When we look at that, global south and global north, and economically, when we are talking about that states, since 2016 onwards, when we look at that, the refugee protections, what we have, some people, they call it as a soft law mechanisms and hard law mechanisms. The rigid framework of international refugee law has been systematically compromised. The narratives have been completely changed. The new norms and new narratives have been set by the not only global north, but it is followed by the global south as well. When it comes to the protection of the refugees or protection of the human rights today, there is not much disparity between a global south and global north. So why I'm making that sweeping statement is very simple. The reason being, number one, when you look at that, the refugee population which are emerged out of the Ukraine or the recent past, when war was going on, and the European Union community has responded as if its entire continental problem, and they have given the asylum across the Europe, including other parts of the globe, particularly in North America. When the same problem was, look at that, the Syrian refugee crisis, what happened? Or maybe Libya's problems, or problem of other areas. They said that these people are emerging out of that particular conflict, are a potential national security threat, hence, and we need to look at device or mechanisms. And they called and they said that they are not refugees. The new norm created that. It is a migration. It is a migratory movement because of certain prevailing situations in the domestic legal system. And hence, when the states are shutting their borders, the international community suddenly said that, okay, let us look into that. Maybe they adopted, a global compact on refugees, what you call it as a soft law obligations. It's a responsibility sharing. So of course, I'm not here to criticize that particular problem, but when it comes to that, addressing the problems of the refugees today, both global south and global north are in one same pace. There is no much difference. But when it comes to the burden sharing, like if you look at that, the burden sharing of the refugees today, it's only falling into some countries like global south, like in terms of Rohingya refugees. Bangladesh and India was facing and witnessing a lot of exodus from the Rohingya refugees. When India is also trying to close its borders, and it's a global south country like Bangladesh, one of the least developed economies, which are trying to address that particular problem with the help of the international agencies like UNHCR and other international non-governmental organizations. So that means the problem in the increasingly changing the geopolitical situation, because of the impact of the geopolitical interest of the certain countries, if the countries are forced to go into the conflict situation, and that conflict situation is emerging out of the global political situation and economic situation, and here what you call it as the outcome of that conflict is ultimately mass influx of the people, and that particular mass influx of the people, there is nobody ready to accept and address that particular problem. Okay, that is a first part of your question's answer. And coming to that digital technologies, like I mentioned that 2013 Australia's Act. Let me mention another important thing, that is 2002. I'm going a little very back, 20 years ago. The aftermath of this global war on terror and attack on the Twin Towers, the government of United Kingdom has adopted the domestic legislation imposing the obligations on the air carriers, saying that if the air carriers are bringing any person, if they are not having any kind of documentation, and it is a responsibility of the air carrier to repatriate them back. And here, the state is shying away from their obligations of controlling the borders, and protecting the people and attributing the responsibility to the non-state entities like air carriers. Most of the private air carriers comes from different parts of the country to the London Heathrow Airport, and they have an obligation. So that means that's why today, if any one of you enter into the airport when you are boarding, and first they will ask you, do you have the valid passport and valid visa? If you don't have the valid visa and the valid permission, and they will deny. Then here, what happens to the citizens' charter of rights, air traffic passengers' rights? What happened? We have the what do you call it as Director General of Civil Aviation of each country has given, in accordance with the International Civil Aviation Organization ICAO's ruling, they have adopted certain charter of rights of the air passengers. Now, when you are going to that board a air carrier, and maybe if in their perspective, if you don't have a proper documentation, and they will deny your boarding. You lose your money, you lose your appointments, you lose everything. And rather, if you engage with an argument with them, and they will look at you as a common criminal, erratic criminal, and they even can blacklist you from that. Let's look at that. This is the problem of not implementing the legal mechanisms where a person who is having the valid passport and citizenship and even travel documents, just because of engaging an argument with a private entity, you become a common criminal and you can be detained for not behaving well. So that means your basic rights, basic charter rights have been greatly compromising. Okay, now coming to that last part of the thing, that is the digital technologies. Like today, the digital technologies like geotagging of the people. For example, if refugee community, if at all they have been allowed to come and stay in the territory of where they are, they got asylum. And here they were taken, biometrics, they have given the geotags, and they have been observed, they have been put as surveillance for the purpose of restricting their movement. And today, most of them have kept in the so-called, what you call it as limited geographical places, and denying the access to the basic essential rights of the people, such as right to life with dignity, like seeking education, having some minimum level of working, and freedom of movement. Everything is restricted because of your geotagging and taking off biometrics by the state authorities. That means a refugee, earlier, if you are given extended that 1951 convention, and you had what you call it as inalienable rights protected under that, but today you are becoming a common criminal, and you have been under the state surveillance, and you are subjected to threats of the national security. So I hope I answered your question. Thank you so much.
Yes, sir. Thank you so much.
We shall proceed further because we are running out of time. May I now respectfully invite Professor Dr. Chetan Singhai, Dean School of Law, Governance and Public Policy, Chanakya University, Bangalore. Sir, before we proceed with you, we would like to introduce you to our audience, then you may proceed further.
Thank you.
I would like to request Ms. Sarah Benjamin to introduce the audience. Sarah, over to you.
It is my privilege to introduce Professor Dr. Chetan Singhai, Dean, School of Law, Governance and Public Policy, Chanakya University, Bengaluru. Professor Singhai is an accomplished legal academic and administrator whose work spans key areas of law, governance, and public policy. He has strong interdisciplinary interests and brings a rich blend of teaching, research, and institutional leadership to legal education. At Chanakya University, he has played an instrumental role in shaping academic programs that connect legal knowledge to real world policy challenges and good governance practices. His commitment to advancing legal scholarship, mentoring students, and fostering an environment of critical inquiry reflects the dynamic role of law schools in addressing complex societal problems. We are honored to have him with us today and look forward to his insights that bridge legal thought with governance and public policy. Please join me in welcoming Professor Dr. Chetan Singhal, Dean, School of Law, Governance and Public Policy, Chanakya University, Bengaluru. Thank you.
Thank you. Thank you so much for this warm introduction. Special thanks to Dr. Vishwanath sir for connecting me to this forum and the organizers and colleagues and fraternity friends from various parts of the world, including my own state of Karnataka. I can see the city of Mysore, colleagues from there. So I think the topic has come at the right time when the world is seeing a transition towards what was there, the life during the Cold War, the post-Cold War, and now the wars, essentially. So in this transition is what we need to reflect on. What is the situation of people who are stateless vis-a-vis the people who are stateful? And stateful are the people who are now on Zoom. Stateless are the people who are dependent on those who are stateful. So I think that's the bandwidth that we need to reflect upon in the spectrum. Now, I want to anchor my thoughts on the larger theme of governing refugee data futures in Global South. I'll bring in three components. The legal protection part, I think most of it already has been discussed yesterday and today, but focus more on the policy power and the digital governance component. So my central claim here is that the refugee data systems now operate at the intersection of public policy, international protection law, and digital governance. But these domains remain poorly aligned. And I think that's where we need to reflect upon as collective, how we can bring that alignment of these three dots, which are on the three different ends of the triangle, and rather elusive triangle. And that's a challenge. So in terms of breaking the three aspects, see, public policy prioritizes efficiency, scale, and coordination on one hand. International law and other aspects prioritizes protection, consent, and also very importantly, the non-refoulement, right? So refoulement has become the order of the day, unfortunately, in today's world order systems that we're talking about, whether it is Venezuela, whether it is Greenland, taking such kind of examples, and also the pushback that we saw in Hungary, where the refugees, actually there was a barbed wire across the country to keep the refugees away. So refoulement is emerging to be a sort of a norm, but also we should be optimistic about the fact that non-refoulement also has continued to be the order of the day in a way, but lying between obligation and morality in the spectrum, right? The third is digital governance, which is very critical today in the 21st century, where I would like to anchor digital governance debates and largely focus on privacy, accountability, and I would call this as algorithmic harm, algorithms, how they're causing harm. So the problem is in the context, that is the global south. So in refugee context, especially in global south, public policy logics dominate, no doubt, while international law and digital governance safeguards lag behind. Because public policy tend to get much more macro view, but whereas the international law and digital governance safeguards are limited in terms of aligning with that macro view at the micro level. So this echoes a very famous scholar, David Lyon's warning that surveillance is not merely a technological phenomenon. It is a social process that shapes power relations. To this end, to all the colleagues and scholars here, I would like to argue that refugee data in the global south has quietly, subtly become a core infrastructure of governance, which was not the case earlier, linking humanitarian protection, welfare delivery, and most importantly, national security, which yet it remains weakly regulated on one hand, fragmented on the other, But more importantly for us here on this forum, it is highly under-theorized, right? And hence what began as an administrative registration for aid distribution for the refugees, which they perform functions that are deeply legal and political. What has happened is refugee data determines now not only who is recognized, who receives assistance, who may move, and increasingly who may be returned. That's the very important part, which is what I've mentioned about refoulement and non-refoulement also, where the state takes the center stage. This transformation raises what I call urgent questions for international refugee law, which our other panelists also spoke about, human rights law and digital governance, etc. So how do I see this transition from humanitarian aid and governance to governance infrastructure that I raised earlier? Traditionally, refugee law concerned itself with territory, borders, physical acts, especially with regard to admission, expulsion, return. Data was peripheral, and data was more supporting documentation and not a governing force. Unfortunately, this transition, that data becoming a governing force, has become a critical shift that one has to reflect upon. So today, refugee governance is built on, I would say, biometric registration systems, right? Interoperable databases, digital identity platforms, cash assistance technologies that we talk about, which is often a scenario at a domestic level, but now it has also become more of the transnational. Can I continue? Hello? Can I continue?
Yes, sir. Yes, you may proceed.
Now, I was talking about refugee governance being built on biometric registration systems. Now, these systems are, as we all know, and we need to flag this, that is, these systems are not neutral, right? They are heavily embedded in different cultural systems, practices, processes, ideologies, and many others, and also intended and unintended consequences that one face in terms of the overarching socio-political and economic scenarios, right? So these are not neutral systems that we talk about in terms of biometric registration systems that refugee governance has become. And they structure access to protection. They also mediate relationships between refugees and states. And when we look at this relationship, we are also looking at embedding refugees within the broader architectures of surveillance and control. Now, how do we then reconcile this shift in the name of surveillance and control? It's a question. I really don't have any specific answer at this stage, because this is something that one needs to empirically evidence on one hand. However, in effect, refugee data has become a form of what I call, this is a quote that Anna Hardant also uses, power quite technical and difficult to contest because of the nature of them being stateless. The agency is under question, and that agency to question and contest is a bigger concern, which becomes much more easier for that earlier point I mentioned, that refugee governance is built on biometric registration systems, which further leads them to be at a receiving end and rather employing the agency to get their issues resolved. Now, what is the scenario? If this is a part of the problem that I've been sharing in the last few minutes, how international law, especially international refugee law, navigates this and responds to this, right? And on one hand, international refugee law provides normative strength, but on the other hand, in the 21st century, it is digitally blind, right? It has digital blind spots, which is, I think, the crux of the last 2 days, yesterday and today's deliberation. Having said that, let us also reflect on how it has a sense of normative strength, which others might have highlighted, but I will just flag it here, and also flag how it is digitally looking at having certain blind spots, which is our concern, and then come back to the suggestions on how to build on it. In terms of normative strength, the 1951 Refugee Convention, particularly Article 33 on non-refoulement that I mentioned in the beginning, continues to remain as a cornerstone of international protection, no doubt. But if you go back to the reference on jurisprudence, such as Soring versus United Kingdom and Hirsi Jama versus Italy, it makes it very clear that foreseeable risks, and indirect state conduct and engage responsibility. If data practices foreseeably contribute to exposure, targeting, or coerced return, they raise direct non-refoulement concerns even without physical removal, and hence this becomes a challenge. And this is where the invisible hands that we all know as market, here comes the invisible hands of the states, using the analogy of the market, coming into the play. So any sense of normativism that we talk about would not have any value if we are looking at this digital blind spot, which is especially the physical versus the non-physical. The non-physical is something which eventually will make them to coerce the physical dimension of it, right? So we are always looking from the top to down, or bottom, top to bottom, but bottom up is also very important, right? Hence, how do we see this from human rights law and refugee data? So international human rights law, particularly as we discussed earlier, and also the ICCPR, I actually almost forgot the abbreviation, but I remember the acronym. It reinforces the protections relating to privacy, dignity, equality, and remedy. Now, there are many such cases that one can refer to, whether it is S. and Marper versus United Kingdom, and Digital Rights Ireland affirms that biometric data and digital records fall squarely within the scope of these protections, right? But do we really interpret it in that way is a larger question. So the jurisprudence behind such case laws that I just referred to creates tension between privacy rights and state security, impacting digital rights jurisprudence globally. But as I again repeat and reiterate, state security tends to trump privacy and other dimensions of the rights that we talk about. Yet refugees are subject to mandatory enrollment, right? And that's where the concern comes. In the name of security of the state, indefinite retention, opaque data sharing, and minimal redress, placing current practices which are there in the systems. And let me take example of Rohingya when I come to the second part of my discussion. So concluding the first part, I still would say that consent and the illusion of choice is a concern here. While I refer to the non-refoulement to refoulement as a preferred strategy and to the international legal systems and the case law that I referred, we see this transition from consent and the illusion of choice. What is the challenge here? Consent in refugee context is deeply constrained, as we all know, right? As I mentioned, the agency is a larger question. How much of agency they have, given that they don't have the minimum wherewithal in terms of institutional mandate to actually engage in contesting and also protesting. That is one part. So there's a constraint already that exists, right? Aid dependency, and more importantly, lack of information. And as a result of these two, absence of alternatives, right, also creates a problem. So consent obtained under such conditions cannot perform its legitimizing role in the law, even as referred to in the 1951 Refugee Convention, for instance, and in general also as part of UDHR. Now, toward creating a legally grounded framework for refugee data protection, I would make 5 propositions, right? And this is subject to further discussion and debate. One is explicit linkage between data practices and non-refoulement, and not to see them as 2 different entities. They're mutually inclusive. Second, binding purpose limitation and firewalling of, that is the technological intervention. We create a firewall of humanitarian data. And there's a lot of pressure and pushback from developed world not to create that for reasons that we all know. Third is refugee specific consent standards, right? Fourth could be independent oversight of actors, especially international actors dealing with data collection, data organization, utilization of data, and for the larger purpose of governance. Fifth would be right to explanation and redress for refugees, right? The current conventions don't have much space for such kind of explanations, right? So hence, I would say, if I put my thoughts in perspective, laws which govern refugee or refugee law in popular parlance was designed for reason was to protect vulnerable human beings and not optimize administrative systems. Let's be clear on that, right? It's because the refugee laws came in response to the wars and the aftermath of the wars and the situations which led to the need of the intervention of the state, but not necessary to optimize administrative systems, which is the demand of the 21st century and the current concerns. Whereas the task before us is to ensure that the data-driven refugee governance remains anchored in protection, accountability, and dignity. And the irony is we get two of the three, but not all three together. For instance, we may have systems for protection, we may have systems for ensuring accountability, but dignity might be not necessarily under the banner of what we are looking at. So let me also, in this context, as a prelude to my closing, recall another very interesting jurist, Justice Robert Jackson's reference here, where he clearly, very interestingly says, and this is more of a analogy as well as metaphor for us to reflect upon, where he reminds us that the Constitution is not a suicide pact, nor is international refugee law. That's the extension of that I am referring to. Nor is the international refugee law a data management manual. It is a moral and a legal commitment to human dignity, right? So this is where the obligation needs to be referred to from morality to legal and vice versa. So hence, as I said, this is an ongoing and current contemporary complex wicked problem to deal with. And hence, I would say shifting the order from what the refugee laws ought to do to what they are supposed to be doing is where the gap exists. And hence, we need to reflect upon it. So I'll stop here at this point. I'm sure there are a lot of questions because the previous session also we had very good questions. So I can come back to that and we can discuss further on it. Thank you so much for this opportunity and hope I was audible. Thank you.
Thank you, sir. Thank you so much for valuable insights and your contribution. We're looking for some questions. Let us have some deliberation. Is there any questions?
Professor Chetan?
Yes, sir.
Yeah, Vishwanath here.
Thank you.
So, is there a situation that has been created, either it is south or north, the hyper-nationalist context or the so-called security concerns have tried to take this refugee context into the southern trend, not the northern trend? Is that one reason that I think we should try to overcome?
Yes, I think in a way, more than hyper nationalism, largely it is more of extended patriotism. This is how I would like the famous saying, one man's terrorist is another man's freedom fighter. So I would put it in that way. But if you see the overarching debates that are happening in India as well, the way we are looking at the borders today to then in earlier systems, and then before that during independence to now, we are seeing that sort of a perception that is emerging, that is a state is seen as more of a provider and not merely as looking at an enabler. So provider, what I meant to say is that over last 10 years, we are seeing a pushback on one hand, that is we are seeing us and the other, which was not the case because our non-alignment movement in the historical context, Gandhism and peace and all others that we have been referring to and living by. But now we are seeing a different approach towards it, right? You need to be not necessarily entitled, but you need to have the rights to access what the state can give. So hence I would create more thicker borders rather than thinner borders. So, and then hence I will practice refoulement in a subtle way and rather not be open about non-refoulement as other states would do. And this, we have seen it in emerging in India, but not necessarily practicing. But we have seen that, as I said, in Hungary, where the Prime Minister clearly announced that anybody coming. So, sir, you have to see from both angles, like what is being done in Global North for the refugees coming from Global South, what is being done in Global South for the refugees coming within the Global South to the other nations. So now I'm looking at Global South refugees going to the Global North for livelihood and right to life. That is one part. Hungary has clearly laid that out and very openly telling that. Whereas south to south, like India has opened up to Tamil refugees coming from the
Sri Lanka.
the post-war scenario, right? And also from Sri Lanka, for instance. So, and also we have seen Kushal Nagar in our own region, Hubli next to your university, the places where Tibetans have been acknowledged. Now, the question is, are we misappropriating their existence in terms of the human numbers that we have? Or are we providing them their own space that they're supposed to be provided as per the laws? Because we are not signatories to the international legal systems as we are supposed to be, but we are still valuing the UDHR as our prime reference. So south-south, I don't see much of this happening, but south-north migration that is happening, refugees, is becoming more of this hyper-nationalist that you referred to. So south-south is still in the emerging mode. With the wars happening across the country, I'm being little pessimistic that it may happen soon. So if that's an opinion only. The first one is an argument. Yeah.
Thank you, sir. Thank you.
Is there any question from audience? We see the participants. I received some questions in my WhatsApp.
Okay.
Yes, there is some question. Is there?
No, I don't see.
Okay, right.
On my chat, but please read out, sir, if it's there. Please read out if there's any question.
Okay, right. There is no question. They have put a message with there. They have not shared there. Right. We shall move to the next speaker of the today. I have privilege to invite Professor V. Vijay Kumar, former Vice Chancellor, National Law Institute, University, Bhopal, and now Professor of Eminence and Advisor, School of Law, Ramaya, University of Applied Science, Bengaluru. Before we proceed, we would like to introduce Sir, and I think he has not joined due to technical reason. Yes, it is there. See. And Ms. Sarah, you may proceed with the introduction of Sir. Let us see.
It is my honor to introduce a distinguished scholar and veteran legal educator, Professor Dr. V. Vijay Kumar, Professor of Eminence and Advisor at the School of Law, MS Ramaya University of Applied Sciences, Bengaluru, India. Professor Vijay Kumar is an internationally respected legal academic with a long and impactful career spanning several decades. He previously served as a Vice Chancellor of the National Law Institute, University, Bhopal, and as a Vice Chancellor of Dr. Ambedkar Law University, Chennai. Before these leadership roles, he was a senior faculty member at India's premier legal institution, the National Law School of India University in Bangalore. His areas of expertise include constitutional law, administrative law, human rights law, laws of elections, refugee law, and humanitarian law, domains that reflect a deep commitment to justice, democratic governance, and the protection of vulnerable populations. He has also held the UNHCR chair on refugee law and has been closely involved with legal education reforms and policy initiatives at national law schools. Beyond his academic specialization, Professor Vijay Kumar has been a distinguished visitor at numerous universities and served on key academic and policy boards that shape legal education and governance frameworks in India and beyond. His contributions, whether in curriculum development, institutional leadership, or scholarly discourse, have consistently demonstrated a blend of intellectual rigor and practical relevance. We are indeed privileged to have with us a scholar whose distinguished career continues to inspire legal educators, researchers, and students alike. Please join me in extending a warm welcome to Professor Dr. V. Vijay Kumar, Professor of Eminence and Advisor, School of Law, MS Ramaya University of Applied Sciences, Bengaluru. Thank you.
Yes, we need to wait just for 2-3 minutes. There is a technical issue, so I will join. So before we proceed with, sir. Is there any other questions?
Hello, good evening. Can you hear me?
Yeah, good evening, sir. Sir, good evening. Sir, we have already introduced you to the audience. You may proceed, please.
Oh, okay. Okay. Thank you.
Yeah, welcome, sir.
Right. Right. Good evening to everyone present here. I would have appreciated if it was a physical interaction. I also see Vishwanath here.
Sir.
Namaskar, namaskar. Because nowadays online methods, they are self-defeating in purpose.
Yes, sir.
Right? And it is such an interesting topic that everyone would like to know the developments, particularly in this area where there are too many stakeholders and too many issues involved in this particular area. So, as this Mysore University is organizing this virtual conference, international conference on legal dimensions of refugee data protection in the age of technology. As an individual, not as a former professor who was holding this UNHCR chair on refugee law, because my notions are always little different from what the UNHCR dictates, because I try to understand international law in a perspective that is a little more practical than philosophical. So UNHCR had certain philosophy, no doubt about it. That is why the institution was created. But the ground realities are entirely different. So therefore, we are speaking on an issue which is very, very important, the refugee data protection in the age of technology. I would have modified the topic a little. Refugee data protection in the age of changing technology. That would have actually, explained the situation, because the moment you think about the law, I think much of the developments have taken place or would be taking place in technology, and making the regulations a little meaningless or irrelevant at times. And therefore, my first observation, initial observation, is that law is always lagging behind the ground realities. And here it is technical realities. So therefore, the moment we try to fill the gap with law, rules, and regulations, I think technology changes, and therefore the gap increases. Now let us keep this point in mind and then look at the developments that are taking place world over in this limited area, keeping in mind the technological innovations on one side and the international developments on the other. I think it was in 2025 September, the UN passed a resolution, and then I think it is about digital policies world over. I think first time possibly the United Nations members would like to come together, and they spoke a lot about the ethics in the area of artificial intelligence, equity between the developing and developed states, and the ability of other nations to, what you call it as, provide assistance to those states which are backward in using or taking the benefit of artificial intelligence. Now, the second proposition I would like to begin by saying, I read this, it is a WhatsApp message which is going around, and I hope all of you would have received it. While intelligence is becoming artificial nowadays, right? I think the what is called as the mistakes committed by the individuals, the stupidity of the individuals will remain original, right? So therefore, we have to appreciate this as well. I'm sorry, I'm just using the technological information available over the web without verifying whether it is right or not. Now, let me just come to the major proposition that the refugee protection in general, as what I have seen till I was teaching this course up to almost 2010 or 2012, was entirely different ball game. Now, with the technological innovations, the refugee protection takes a different route altogether. It is in this regard, the protection, the additional protection given to the refugees, particularly the personal data protection of those claimants, right, is very, very crucial. And I will also explain what are the recent developments vis-a-vis the developed nations that have been receiving refugees over a period of time, what happened to them. So we need to take a holistic picture or the realistic picture of what is happening, right, in this scenario in the world over. And therefore, the term refugee protection basically involves a very vast legal, social, and political data, right, which were very difficult to obtain, and even if you obtain, very difficult to verify, right? And that is why we have taught many case laws, judicial decisions of many developed nations where they give some wrong information and get into the other countries, and they find it very, totally wrong information that they have provided, and they try to evict them, and then it becomes a different issue altogether. So therefore, it is very difficult to obtain earlier, but very easy to get them in the AI era, right? Because everything is now open, and that is why you will see high profile people, they don't keep these high-tech mobile phones at all, right? So that they need not be, or they should not be tracked, by the information regime. And therefore, this is also taking place side by side. And these data, the political, social, economic, right, and legal data obtained from various sources complicates the issue further, right? But these data received or to be collected are necessary to check the reasons for the flight, the countries or territories transited by them. Because there is also, when I use the term transited, there is also another group, right, which takes the people from one port to another port by collecting huge amount of money and throwing them near the shore, or sometimes even making the vessel drown in the open sea. All these things are happening. The human smuggling is also part of that. So the way that they transit all these international borders is equally important. The reasons for the flight, the countries transited by them, the legal regime in the sending state to understand whether they really are necessary for the determination of the status, and the legal regime in the receiving state, right? Now, with many countries, or I would call it as refugee receiving countries, like the US, UK, European Union, and others, the data becomes very crucial for them today to reject a large number of claimants at the threshold of entry. And now it is possible for them to check the data at a later point of time, even if they are admitted and they are thrown out of these states, in groups, in large number of, people, right, who have been admitted, but now they found, it is difficult for them to accept them and send them back. I think recently what has happened to large number of illegal immigrants, they call them, to India, to Africa, to South America, and even to China, right? Flights were carrying all these people back to their respective countries where or which they fled some time ago. So this is something very important, because all these things are possible because of the access to the information about their the refugees' wherewithals, and that is one among the reasons why these nations are doing this, right? Returning them to their state of origin, right? And it poses a huge challenge to privacy and personal data protection of claimants in the contemporary world. Now, earlier, I still remember I was delivering a lecture at the International Institute of Humanitarian Law, right, in Italy. And there my topic was balancing between refugee protection, right, and national security. Now, two extremely sensitive topics, national security on one side and the refugee rights on the other, right? And you are supposed to balance between these two. And today, I hope the same logic continues in a different format. The national security of the receiving states on one side, and the human rights of the claimants, whether they are called as refugees or internally displaced or immigrants, illegal immigrants, whatever title one may give, or asylum seekers. I think this seems to be a changed topic, but with the same vigor. The national security of the states concerned on one side, and the human rights of these refugees, particularly the personal data of these refugees, which are very, very necessary or very, very essential for the states to accord them the entry, regularize their entry, legalize their stay, and then particularly grant them, rehabilitate them, give the necessary relief, and also take them there as permanent citizens and things like that. So therefore, ladies and gentlemen, data protection in international refugee law centers on safeguarding highly sensitive personal information of vulnerable individuals, vulnerable claimants, right? Primarily through the guidelines from UNHCR, which I would like to spend some time more little later as to what is happening and what UNHCR is doing, and the International Organization for Migration, which emphasize more on confidentiality, purpose limitation, consent, and do no harm, ensuring data isn't shared with persecutors, and balancing humanitarian needs with privacy rights, especially with new tech like blockchain. The key principles include transparency with refugees about data use, security measures, and respecting data subjects even while enabling aid delivery. I think a whole lot of issues are involved in the different aspects of the flight of the refugee from the state of origin via various borders, state borders, or the vast oceans, the receiving states, initial aid and assistance given to them, relief given to them, and accommodating their needs at a later point of time by the states. Therefore, ladies and gentlemen, the increased databases of claimants for admission based on the needs of the receiving states. I would like to use this opportunity to make a mention about it. The receiving states had their own agenda, political, economic, social as well. Many of the Western countries where the population growth diminished over a period of time, and they had the necessity to maintain what you call it as optimal population. That's number one. Number two, they needed what you call it as a large number of workforce, which is not locally available, and therefore they were using this refugee law in one way or the other to accommodate them and to demonstrate to the whole world that they were doing something philanthropic, right? Doing something good to the people, but ultimately the real color of these nations get to see in the recent past, starting from Australia about 2 decades ago, to what you call it as the present developments in the US, Canada, UK, and the European Union. So therefore, friends, we need to keep this in mind that the area or the scope for the refugees successfully claiming refuge elsewhere is diminishing. It is in this context, if somebody claims and somebody insists or somebody focuses more on the data protection, I think the states are not willing to accept them. So there is a huge conflict of interest between the national interest and the national security of the receiving states, and on the other side, the demand for the data protection of the refugees, right? And which the primary organizations involved, the UNHCR and IOM, right, gives some idea about it. I was going through before, when I accepted this morning I received a reminder call that I have a presentation this evening. So I just went through some of the documents and also looked at the UNHCR policy on data protection as well as IOM's policy on data protection. They are all very beautifully drafted. Ladies and gentlemen, drafting skills are extraordinarily brilliant, no doubt about it. How far and to what extent they are practicable or implementable is a huge challenge, right? Because there is a possibility at every level. They have to pass on the information which they receive to different agencies within the state and different agencies outside the state, because it is the national security, not when they land in the respective nations, but even before they come, they would like to verify everything. So therefore, when the data passes from one hand to another and ultimately to the judicial decision makers, I think too many changes of hands of data is not very safe, right? I'm telling this because the human frailty is such that any point of time, if it leaks, that is the end of it. Whatever the state is trying to do, I think is one aspect of it. But in spite of all these things, data leaks do take place, and data accountability and other issues are all slowly coming into picture, right? And therefore, we have to appreciate this policy in that particular perspective. Very quick review of this UNHCR policy, which applies only to UNHCR, right? Which is purely based on the UN Personal Data Protection and Privacy Principles adopted by the UN, right? Way back in 2018, October 2018, right? This policy of UNHCR, ladies and gentlemen, applies to the processing of personal data, and it does not apply to the processing of non-personal data, including anonymous data. I want you to keep in mind, and I don't think we will have time to look into what this non-personal data would be, because the data is now classified on broad personal as non-personal. If there are certain items involved in non-personal data, from there AI can track, the artificial intelligence can track and date back. And I think we have seen what Grok could do, right? In managing the videographs of particularly women and children, and the ban imposed on that. I think AI can do much more damage even on non-personal data, and possibly, I'm not sure, I'm not a technical person, possibly the non-personal data would lead to the personal data at some point or the other, right? The facial recognition software, right? The fingerprints, the fingerprints, the iris that they take, they capture at each and every port of entry or exit. I think these are all open, and I think the damage that they can do is something phenomenal which we are not able to assess in a meaningful manner. Therefore, it is very difficult to put forward, please safeguard them. But still, one aspect of UNHCR policy, I will not dwell details about the policy, is about the redressal mechanism within that policy. And when the redress request is granted, right, the remedies available to the data subject are limited to one or more of the following. That's what the policy is saying. I would like to just read out these 5 or 6, right, possibilities. The first one is the provision to the data subject of information in relation to a specific instance of processing of their personal data, as given in paragraph 30. I will not get back to 30. The second one, the provision to the data subject of a copy of the personal data being processed. The third one, the rectification of inaccurate personal data or the completion of incomplete personal data, which in my opinion is absolutely necessary and good. The fourth one, the deletion of personal data. Very easy to say, but maybe UNHCR will do it, but the states concerned, the receiving states, will never do it. Otherwise, they cannot take the record that after 10 years, they say that you have given wrong information, right? Misrepresentation. On that count, we would like to repatriate you now. You are helpless. Therefore, the states would like to cling on to the data that they receive, but the UNHCR may not. The fifth one, the cessation of temporary suspension of the personal data processing. And finally, which is very practical, a written apology to the data subject. Right? I think it takes us nowhere. A written apology means nothing to that individual, but still, this is what in the same policy, something very funny which I see is, in no event will UNHCR be liable to pay financial compensation are required to make public announcements or statements. So on one side it is giving policy, on the second side it is trying to wash off its liability part of it. And I think rightfully so, because it is an agency, humanitarian agency, and that itself is not having adequate fund nowadays, and therefore imposing a sort of financial constraint on UNHCR will be too difficult for anyone to enforce it. Now, when you come to the IOM policy, which is even more elaborate and nice, I will not go through this once again. It speaks about lawful and fair collection of data, right? Specified and legitimate purpose for which the data is collected. The data quality to be maintained, that is, from the time you receive it, record it, process it, the quality is to be maintained. The consent to be obtained by the state concerned or the institution concerned, right, from these data subjects. The transfer to third parties, in which adequate safeguards to protect confidentiality of personal data and to ensure the rights and interests of the data subjects are to be respected. This is also very good, very beautifully said. But once again, ladies and gentlemen, on the implementation part of it, we are likely to fail. That's my feeling. I may be wrong. Please correct me if I am wrong. Right? And then in this point on transfer to third parties, IOM itself, the International Organization for Migration, is also involved in multi-agency relationship, right? And therefore, it has to share this data to multi-agency, right? And then for relief, rehabilitation, and return. Now, how are they going to? They may say that please maintain the secrecy, but how they are going to ensure, I am not very sure. Even if IOM does, what about the other agencies? We are not very clear, right? Confidentiality of data at all stages to come, and access and transparency, right, to the data subjects, not for others, right, for which personal data are collected and processed. And the data controllers should ensure general policy of openness towards the data subject about the development, practices and policies with respect to personal data, which once again is in a fluid state of affair and changing state of affair with technology changing every now and then. Then data security, retention of personal data, then application of principles, ownership of personal data, I think so on and so forth. And it also speaks about another important aspect, oversight, compliance and internal remedies, right? And they have appointed an independent body to oversee the implementation, which is a welcome measure. And there are exceptions to this, right? And I will not get into the details of what they say. Now, data protection in technical side is one and the legal side is another. There are many states which are not even willing to accept, right, the importance or significance of data protection. They keep on collecting left, right, and the center. The human behavior is also equally important for us to understand. I would like to just give you one example. There was an international exhibition in Bangalore, which I visited. Usually they used to give a ticket, you buy it and then enter. And then earlier they used to give in the ticket, you put your name, contact the coordinates in detail so that they can contact you later, or there is a lucky draw that you may be sent to Sri Lanka or Nepal or some other place. So everyone is interested in filling up that format, and then ultimately this data is rolled into and sold to other people as well. And I think this policy will also catch up with the states to collect all this information in some form or the other. And therefore, data protection continues to be a growing field in the context of international organizations themselves, right? The issues involved may be management of huge data. That's number one. Data theft I don't know how much they can prevent it from data losses and unnecessary or inappropriate use. And finally, disclosure of sensitive data, right? All these aspects will continue to play an important role. Maybe a few more paraphrases, few more phrases may be added to this list, and we have to wait and see. Now, in this scenario, I would like to just flag some of the developments that have taken place in the recent past. The policy of the UK, right, which drastically changed, right? They wanted to prevent refugees or asylum seekers coming, right, through the sea ports, any of them. And then they have put what you call it as the Coast Guard ships everywhere to drive them back, which we don't get to know what's happening really on field. Now, this has changed a little now. Things are changing, no doubt about it. The European Union is another, which I think in the last few decades, which I have seen, repatriating the refugees who have been accepted as refugees, and Germany and other countries giving what you call it as incentives to the African nations to take them back. And I'll tell you, they were selling these accepted refugees. If they accepted one refugee by any of the African nations, they will give $3,000, right? It is the money which makes the repatriation possible. When all these things are taking place, I really doubt whether these countries in European Union will strictly enforce what is there in law, or would they like to keep the national interest and give some additional weightage to national interest for the time being because of the conflicts that are taking place in and around the European Union, right? So therefore, the EU immigration and asylum system is governed by a dense, complicated web of law and practices. I need not elaborate on this. It is very humanitarian, human rights oriented, but today the practices that we see around are little complicated, little different from what we read, right? The personal data gathered, stored, and processed through these systems may be crucial in the assessment, and you have the license to travel within the European Union. You need to give all these things, the information, share them with all the countries within the European Union. That is a place where there is a possibility one nation may be very strict, the other nation may not. The liability may be there, but to what extent national security will take over in determining what technology should do or should not do is left to them. I would like to just move on and refer to 3 or 4 decisions of the courts on the data protection, right? Because the increasing amounts of personal data gathered from various people crossing borders, understanding data protection laws and its use will only become more important, complicated, conflicting with the interest of the state versus the interest of the asylum seekers or the people on the move, right? Let us keep this in mind. There are judicial decisions in international refugee law which increasingly address the data protection as a fundamental component of human rights and therefore the refugee protection as well, particularly in the digital era. The courts nowadays are scrutinizing state practices involving the collection and use of asylum seekers' data, such as from the mobile phones and social media, to ensure they comply with data protection principles and do not violate rights to privacy and dignity. Now, in my opinion, please correct me if I'm wrong, I'm also in the process of learning all these things. Now, as long as the data is collected by the state or the state machinery, it is fine. Some sort of check and some sort of control, some sort of regulation can oversee it. But if it is through the social media, right, and there are non-state actors holding vast amount of data, right, and that is a place the complications are likely to arise, right? And therefore, I would like to refer straight away, right, to some of them. I already mentioned to you about UNHCR data protection policy, the European Union GDPR, right, that policy. And then there is also judicial guidelines, the International Association of Refugee and Migration Judges. It has developed guidelines, including for the analysis of social media evidence with emphasis, which emphasize the need for judges to have a general knowledge of technology and to consider human rights concerns, right? Some of the decisions which I would like to refer to very quickly, as I am running out of time, right? Let me quickly refer to this three at least decisions. The German Federal Administrative Court very recently in 2023, right? The court ruled that the Federal Office for Immigration and Asylum must change its practice of routinely extracting data from mobile phones, from mobile phones of undocumented asylum seekers. See the qualification, from the mobile phones of undocumented asylum seekers. Authorities must first check for other less intrusive, so they have to check other less intrusive forms of identification before resorting to phone data extraction. So they are not ruling out the extraction from mobile phones, but they only want that the other non-intrusive or less intrusive forms of identification to be used first before resorting to phone data extraction, which was deemed a disproportionate interference with the right to informational self-determination. What a beautiful phrase it is. Informational self-determination. And I would request, if there are researchers in the gathering, the students or the faculty in the gathering, I think they should take up this phrase, right? The informational self-determination. We have seen self-determination in various forms in politics and international relations, right? But now we are seeing this as informational self-determination in that specific case, right? A wonderful phrase. I have learned something on this self-determination, informational self-determination. The second one, the Belgian Constitutional Court recently reviewed legislation on accessing electronic devices and ruled that authorities are not authorized to conduct unlimited searches. Now, as a student of law, when I read this, right, not authorized to conduct unlimited searches, which means it permits limited searches, right? So as a student of law, I would like to see the negative side of it also. Conduct limited searches, so it is possibility. The decision to request access must be communicated in writing, and the authorities can only consult elements shown by the applicant. This is the second decision on this particular subject, which I think we need to go in detail. I did not go through the entire judgment, but I think the crux of it I read somewhere, so I thought I'll share it with you. The third one is UK Court of Appeal, right? That is AAA, that is a Syrian claimant and others, versus the Secretary of State for the Home Department, which addressed the legal relevance of data protection breaches in the context of UK's Rwanda relocation policy. Now, the moment you think about relocation policy, right, something else need to be. Oh, okay. Somebody is sending a message. Right? Okay. I'll just take another 2 minutes to wind up, and therefore I'll leave it to the organizers to complete the proceedings. Right? The case explored whether such breaches are relevant to the overall validity of public law decisions in asylum management. Right? Data sharing and confidentiality. The judicial review cases in UK have challenged Home Secretaries or Home Office's policy of sharing data of victims of serious crimes, including that of domestic violence, with immigration enforcement, arguing that this is inconsistent with the primary purpose of police protection and a potential breach of Data Protection Act and ECHR rights. Right? These decisions underscore that data protection is not a minor issue, but a critical safeguard against other human rights violations, such as refoulement based on mistaken identity or discriminatory algorithmic assessments. Ladies and gentlemen, I would like to just give you one important issue or a case study in which a lady was sent deported back to Bangladesh recently. She was in the advanced stage of pregnancy and she was about to deliver a baby, and some of the NGOs intervened and raised objections, and finally the court granted a re-entry and she came back to India and delivered the baby, right? And if this is possible, I think on humanitarian and human rights considerations, we need to look at data protection in that perspective rather than simply theoretical, right? There is an increased amount of national security concerns among all nations, developing or developed, right? And that cannot be compromised with data breaches or data protection as a right, as a basic right, when the refugees or the claimants cross several borders and reach the shore of another state, knocking on the doors of that state to provide them what you call it as asylum. I have much more other issues also in my presentation which I wanted to discuss, but I think I will stop here. On refugee protection, September 2022 is also relevant. If time permits, please look at it. And I would request all the researchers. I'm out of the National Law School holding the refugee law chair. I taught a couple of years thereafter. I'm also losing sight of this refugee law, but I keep reading these developments in and out. I would appreciate all the students and the researchers to take this area much more seriously. And I think the future of the asylum seekers will be based on your research findings in the years to come to protect their privacy, right? And also at the same time balance with the national security of the states, particularly the receiving states. Thank you very much for your patient hearing.
Thank you, sir. Thank you so much. So we come to the concluding segment of the second day. Now I invite Ms. Sarah Benjamin to kindly propose a word of thanks.
It is both an honor and a privilege to deliver the vote of thanks at the conclusion of the technical session of the two-day international conference on the legal dimensions of refugee data protection organized by the Department of Studies in Law, University of Mysore. At the very outset, I extend our deepest gratitude to our chief patron, Professor Dr. N.K. Loknath, Honorable Vice Chancellor of the University of Mysore, and our patron, Srimati M.K. Savita, Registrar, University of Mysore. Their constant encouragement, academic leadership, and unwavering institutional support have been instrumental in the successful conduct of this international conference. I express my heartfelt gratitude to our guest of honor, Professor Dr. V. Vijay Kumar, former Vice Chancellor, National Law Institute, University Bhopal, and Professor of Eminence and Advisor at Ramaya University of Applied Sciences, Bengaluru, for graciously joining us and for his distinguished presence that added great value to today's session. A sincere note of thanks to our keynote speaker, Professor Dr. Anupam Jha, Professor in Charge, Law Center 2, University of Delhi, for his enlightening keynote address that set a strong academic foundation for the technical deliberations. We are deeply grateful to our distinguished speakers, Professor Dr. Srinivasalu N.S., Professor Dr. Banerjee Chakka, and Professor Dr. Chetan Singhai for their scholarly contributions and thought-provoking insights. We also extend special appreciation to Mr. Rudy Martinez of the Kalu Institute, Madrid, for his engaging presentation and for bringing valuable international perspectives to the discussions on refugee data protection and displacement studies. We also place on record our gratitude to the Kalu Institute, Madrid, Spain, for its academic association and support in this conference. A very special note of appreciation to Professor Dr. Vishwanath M., Senior Professor and Dean, Faculty of Law, Karnataka University, Dharwad, for his constant support and encouragement over the last 2 days. His guidance and goodwill have been a great strength to this program. We gratefully acknowledge Professor Dr. M.S. Benjamin, Dean, Faculty of Law and Chairman, Department of Studies in Law, as President of the program, for his visionary leadership and guidance. Our sincere thanks also goes to Dr. Syed Kudrat Hashmi, coordinator of the program, for his tireless efforts in planning and executing this conference with remarkable precision. Most importantly, we extend our sincere appreciation to our technical and media team support, Mr. Millen, whose dedicated efforts behind the scenes ensured smooth streaming, seamless connectivity, and flawless technical execution throughout the conference. His work, though invisible to many, was crucial